Hi, welcome. This is a regularly scheduled meeting of the Blue Ribbon Commission on the Future of the California Bar Exam. I'm Josh Bertula, the chair of the commission. We are going to begin by taking roll, please, Devin. Uh-oh.
Hi,
Robert?
I'm going to be taking roll today.
Okay, thank you.
Bakshian,
Present.
Boyd,
Present.
Chan, Dugan,
Present.
Evans, Gardena,
Here.
Harrison,
Present.
Dr. Henderson,
Present.
Esther Lynn,
Here.
Montez,
Here.
Bertula,
Here.
Judge Reeser,
I'm present.
Natalie Rodriguez,
Present.
Judge Rossi, Scavoletto,
Givoletto, I'm here, thanks.
sorry about that,
That's okay.
Silverman, Mylan Spencer, and Williams.
Present.
Okay, we have quorum.
Fantastic. I'm going to begin today with short chair's remarks, and then we're going to move to public comment before we get to business. I have two quick topics. The first, I just want to thank everyone at the last meeting. I unfortunately was not able to participate, but really appreciated the open dialogue and felt like we were able to move through some really difficult content and have some discussions that will be fruitful for today and ultimately for recommendations and decisions. So I thank everyone for their hard work during that process. Second, I just want to mention, as some of us know, the extension of the provisional licensure program by the California Supreme Court. The court issued an order to extend the program for 2020 law school graduates to December 2022. I personally have been watching that program as I was part of the board of the California State Bar Board of Trustees at the time that program was recommended and then adopted by the California Supreme Court. And I've always been excited about the success of the program. Obviously, the program has been meaningful for those involved. Although it is not within our purview, the board and the court obviously have been taking information, watching it closely, and it will be obviously part of any long-term decision around the future of the bar exam. Today, with our time, we're going to focus on non-exam pathway like we did the last meeting, and really on the framework that we talked about, specific questions and answers, and try to get to some decision making. We'll have a couple presentations and some facilitation from the staff, and hopefully, if not today, at the next meeting, can really arrive at recommendations where there's consensus and we feel like direction towards our recommendations. With that, let me make a couple of comments on public comment, and then we can start. As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting. The commission has received written public comments and distributed. We will attempt to call members of the public in the order that they appear. We ask that you limit your comments to 2 minutes. And I believe that, let me just touch on the logistics for raising hands. I think we've been through it now for a couple of years, but those that are just joining for the first time and haven't participated before, if you're participating via Zoom, you should have a function to virtually raise your hand. It's the hand icon at the bottom of the center of the screen. If you want to make a public comment and you're participating by phone, you can virtually raise your hand by pressing *9, star key, and then the number 9 key. And with that, if we can start calling public comment, please.
Our first public comment from Rianne.
Hello, and thank you for the opportunity to comment. My name is Rianne Pacheco, and I am the Senior Advocacy Associate at the Legal Aid Association of California. LAC works directly with over 100 nonprofit organizations funded by the State Bar of California. We know the demand for legal services is great, and we do not have enough legal attorneys in our state to meet the need. To reiterate the earlier comments, the Bar's creation of the provisionally licensed lawyer program and its extension of the program through later this year is a great opportunity to learn from the legal aid community how these employees were able to help serve low-income Californians in legal crisis through well-organized nonprofits that are already monitored by the State Bar for the grant compliance reasons. We support exploring alternative pathways to licensure and urge the Bar to survey the organizations that worked with PLLs to learn more about the impact of those legal workers who did not need to pass the California bar exam in order to help people. We ask that you continue dialogue surrounding a phase-in commitment to practice legal aid, but most importantly, we encourage you to seek legal aid input as you continue to do this important work. Thank you for letting me comment.
Next public comment from Eric.
Dear members of the Blue Ribbon Commission, my name is Eric Abramian, and I'm a provisionally licensed California lawyer. I acquired my license in the fall of 2021 and began practicing with my supervisor in the fields of both corporate transactional law and civil litigation. On behalf of the small group of provisionally licensed California lawyers, I would like to thank the Commission for its compassion during the last 2 years and its creativity in the work that it's been doing to advance alternative pathways to licensure. We are proud to serve as the original members of this pilot project that has been tremendously successful in showing our competence to practice with support from our supervising attorneys, clients, and the legal community at large. We're also supportive of the group of newly licensed lawyers who have benefited from our program by achieving what would today be considered a passing score on the bar exam, but was not at the time they sat for the exam. We ask that the Commission creates an alternative pathway to licensure for all 2020 PLLs. Such action would be the natural next step of a program that was created to determine our competence and to challenge its participants by applying the law to real life and assisting real people. There simply is no group of lawyers more qualified for an alternative pathway to licensure. Many of those whose bar exam scores were retroactively applied to our program, creating a pathway to licensure for them, had not even been practicing in the legal industry for years. Unlike them, we are recent graduates who have demonstrated our competence as lawyers for the past 2 years. And while I'm not an expert on exam scoring, I would assume there's some disparity between a passing score of 1390 today and a 1390 in the context of the exam pre-2020. While we're so grateful for the California Bar welcoming us into this program, we would not be in this predicament today if it were not for the opportunities this program provided. We urge you to help us out of this mess that we ironically are grateful you got us into. We are passionate about what we do. We chose California and trusted this program in beginning our careers in this state, and now we're fighting for a chance to continue on the path we have entered. Thank you.
Next public comment from Benjamin Cohn.
Thank you. I am commenting to encourage the Commission to use the existing framework for exemption from the first year law student exam to determine eligibility for the non-exam pathway that starts during law school, as well as any that are after law school. There should not be an issue for out-of-state law students and out-of-state law graduates who attended ABA accredited law schools as far as needing to take the bar exam anyway because they didn't choose an in-state law school. Such a pressure would artificially restrict educational opportunities for prospective law students whose budgets or learning styles or particular interests with the law could be better served academically out of state. And the framework that the State Bar found adequate for the first year law student exam exemption should be extended forward for that reason and general fairness. Thank you.
Next public comment from Sebastian.
Good morning to all members of the commission. My name is Sebastian Bendick, and I've been a provisionally licensed lawyer since November 2020. The provisional licensure program was created by the California Supreme Court in response to the COVID-19 pandemic and is scheduled to expire December 31st, 2022. I've been following the Blue Ribbon Commission's work for the past year and have attended each monthly meeting. I applaud the actions that this commission has been making. The open-mindedness of the commission is refreshing, taking into account not only interstate sources, but as well considering international sources to model from and modify. I'm thankful that this commission is prioritizing the interests of California law graduates, as well as the public interest sector, which ultimately maximizes the interests of the people of California. The Rule 9-49 PLLs have a wholehearted request for this commission to create a supervised pathway to licensure for all Rule 9-49 PLLs. Most recently, the District of Columbia has implemented a supervised licensure program for 2020 law graduates who completed 3 years of supervised practice, thus creating a full pathway to licensure. The state of Oregon is proposing and supporting a full pathway to licensure for 2023 law graduates who complete 1,000 to 1,500 hours of supervised practice. As the Blue Ribbon Commission continues to develop recommendations, I request that the Commission remain aware of the rigorous work that the class of 2020 PLLs has engaged in and how on average each PLL member has completed upwards of 2,000 hours of supervised work. I ask for your consideration and support in recommending to the State Bar of California Board of Trustees to establish a supervised pathway that leads to full licensure of Rule 9-49 PLLs. Personally, I've worked over 2,750 hours practicing public interest law in the areas of deportation defense, domestic violence, and eviction defense. Over this period, my legal duties have included client intake, assisting with legal strategy for litigation matters, drafting answers, propounding and answering discovery, researching discovery response objections, filing depositions, special appearances, stipulation agreements, motion for summary judgment, motion for judgment on the pleadings, jury document preparation, trial appearances, final status conferences, mandatory settlement conferences, order to show cause, etc. I have substantially evolved as a legal practitioner since the implementation of the provisional licensure program in November 2020. I do believe my work product speaks for itself and invite any member who wishes to review it if it would help the Blue Ribbon Commission develop an alternative pathway to licensure in the state of California. The PLL program has been a positive benefit, positively impacting the lives of PLLs, our firms, our clients' lives, and the state of California collectively. Thank you all. I waive the rest of my time.
Next public comment from Andrea.
Good morning. My name is Andrea Marquez, and I would like to thank
I think she was cut off.
sorry about that. I believe that a pathway to full licensure should be offered to all 2020 provisional lawyers based on the skills and experience we have developed and demonstrated since the program became available for us. I began using my provisional license in January 2021, and I have been practicing full-time in the area of personal injury. As a provisionally licensed lawyer, I have practiced law under the supervision of an attorney for a term of over 3,000 hours, which does not include the hours I will complete before the end of the year. I am managing over 100 cases, which has allowed for me to handle a variety of tasks. In addition to pre-litigation work, such as client intakes, client communication, and demands, I am responsible for negotiating cases, preparing and filing complaints, propounding and responding to discovery, noticing and defending depositions, preparing stipulations and oppositions, conducting legal research, preparing trial documents and binders, and countless other duties. Currently, I am the only Spanish-speaking associate at our firm. I've translated legal documents from English to Spanish and have been the primary contact for our Spanish-speaking clients. In addition, I have brought in 15 cases to our firm just this year alone. I would not be here today if my supervising attorney and myself did not believe that I am more than capable and competent to practice law as an attorney. I respectfully request the Blue Ribbon Commission's support in providing us 2020 provisionally licensed lawyers a pathway to full licensure. Thank you.
Next public comment, Tony or Tony.
Town. Thank you. My name is Drew Town Morton, and I have been a provisionally licensed lawyer under Rule 9.49 since May 2021. I ask for your consideration and support of recommending to the State Bar of California Board of Trustees of establishing a supervised pathway that leads to full licensure of Rule 9.49 California Rules of Court PLLs. I have worked over 2,024 hours under this rule since May of 2021. I have worked as an attorney with the Legal Aid Foundation under Rule 9.49 with the Santa Monica Work Group. Many, if not majority of the 9.49 counterparts and I have all pursued our passions in public interest law, which is a testament to the civility, integrity, and ethical characteristics of the approximate 200 to 300 PLL licensees who seek a path to full licensure. Like the Blue Ribbon Commission, we are committed to continue promoting the highest standard of these characteristics and professionalism in the legal profession. The Commission's guiding principles include setting the foundation for the successful practice of law and ensuring the protection of the public. If the Commission examines the empirical data of the Rule 9.49 licensees, you will find that our extensive work product, civic engagement, and adherence to the California rules of professional conduct shows that we are more than prepared to practice law ethically and competently at a level appropriate for an entry-level attorney. During my time with the Legal Aid Foundation, I have worked in a multifaceted capacity where I have represented and aided low-income residents of Santa Monica in landlord-tenant cases, including eviction defense, fair housing, disability rights, and rent control law. Further, I run the domestic violence clinic at the Los Angeles County Superior Court in Santa Monica while actively helping domestic violence survivors obtain protective orders against their abusers. During the pandemic, LAFLA pioneered remote domestic violence and family law Zoom clinics for all of Los Angeles County for low-income residents, where I had the privilege to oversee countless pro bono attorneys, law students, and volunteers to ensure the protection of the public. Quantitatively, in the last 368 days that I have been practicing under the 9.49 DLL license and have been employed with the Legal Aid Foundation of Los Angeles, I have billed a total of 2,024 hours, oversaw, ran, and billed approximately 300 hours to the DV clinics, and have been the primary legal advocate for over 221 cases and clients, averaging almost one per workday. I have billed over 1,200 hours directly to casework and client aid. Out of those 221 cases, I've had 145 family law related cases. 100 of those cases are related to obtaining a DVRO, domestic violence restraining order, renewing a domestic violence restraining order, or enforcing a domestic violence restraining order. 5 of those cases included litigation or obtaining an elder abuse restraining order or a civil harassment restraining order. And 25 of those cases was related to divorce petitions with or without children, filing for default, request for emergency orders, annulment, and general counsel advice. Out of all of my family law cases, over 70 of them involved minor children, including domestic violence restraining orders for minor children through guardian ad litem's, request for order, custody, visitation, modification, and ex parte emergency orders. With my housing work, I have represented over 22 clients that are Section 8 voucher holders. 10 of those, I have wrote reasonable accommodation letters, and I've worked with countless city actors and landlords. I have substantially evolved as a legal practitioner since the implementation of this program and commencing my employment with LAFLA. I do believe my work product speaks for itself and invite any member to review our empirical data including billable hours, outreach, and our employment. And I have this data readily available that can be verified by my employer. And I appreciate your time. Thank you.
Next public comment from
Yeah,
Claire.
Devin, excuse me, one quick question.
Mhm.
Out of fairness, can we please make sure somebody's tracking 2 minutes on time? I don't want to be unfair to others that didn't have the full time.
Sure.
Thank you.
Good morning. This is Claire Solot from the Legal Service Funders Network. It is wonderful to once again be with all of you. I'm going to keep my comments very brief and in two parts. The first relates to the 2020 PLLs. We are extraordinarily appreciative of the extension of the PLL license. In concept, however, in application, what this results in is PLLs have to stop working as they prepare for and take the upcoming July 2022 bar exam, which is a hardship for them, their organizations, and their clients. Time is of the essence, and we respectfully ask that the Blue Ribbon Commission makes the recommendation, as has been very well articulated by many PLLs today, that there be an immediate pathway to licensure option that is implemented for this community. As to the future of the bar exam, as demonstrated in the materials that the LSFN submitted, we believe that the postgraduate pathway to licensure is the best option for a variety of reasons, as I've articulated in the written materials submitted. And I'm happy to provide any follow-up comments or answer questions. As we all know, supervised practice has historically been the main method of licensure. And we encourage that this be added to the options that we have in California, recognizing that this can be implemented immediately, and the revision of the bar exam and a law school pathway will take years to implement. Thank you so much.
Next public comment from Nicole. Nicole, you've been given the mic. Okay, moving on to Brad.
Good morning. My name is Brad Baldwin, and I've been a provisionally licensed lawyer since December 2020 under California Rules of Court, Rule 9.49. I've been following the commission for the past year. I applaud the commission on its efforts to explore developing recommendations concerning whether and what changes to make to the bar exam and whether to adopt alternative or additional testing or tools to ensure minimum competence to practice law. As the commission continues to develop such, I implore and propose for the commission to study us Rule 9.49 PLL 2020 grads and the legal work they've completed under licensed supervision. There's roughly 200 to 300 of us who have been provisionally licensed since the inception of the PLL program back in November 2020. I respectfully ask that the commission recommend to the State Bar, California Board of Trustees, and inquire in hopes of facilitating a survey process of all Rule 9.49 licensees and their supervising attorneys to gain further insight as to the scope of work product us 200 to 300 licensees have completed since they've been provisionally licensed. I believe this would be beneficial to the commission as you continue to develop additional recommendations concerning what changes to make to the bar exam and whether to adopt alternative or additional testing or tools to ensure minimum competence to practice law. Ultimately, with the commission gaining more insight and survey research results about us PLLs, I would thereafter ask for your consideration in support of recommending to the State Bar of California Board of Trustees of establishing a pathway that leads to full licensure of the Rule 9.49 California PLLs. In my own 18 months of supervised practice, I've worked over 3,000 hours under a licensed attorney, specializing in real estate litigation, landlord-tenant litigation, general civil litigation, real estate transactions, and transactional estate planning. I believe I've worked within.
Comment has exceeded 2 minutes.
Moving on to the next public comment, Billy.
Hello, thank you for giving me the time. My name is Billy Strello. I have been a provisionally licensed lawyer since December 2020, where I have worked at Root and Rebound. We are a nonprofit organization that works to support formerly incarcerated people and their families and communities across the state. As the previous speakers have so wonderfully said, I absolutely want to thank the Commission for your hard work and the time you have spent listening to us and to other feedback from those in the community regarding a proposed pathway to licensure. I would in particular also like to echo a previous speaker who spoke about their work in the public interest field and how vital it is for California to have more barred attorneys working for underserved and marginalized communities. I would also support the Commission in surveying our supervisors and the organizations PLLs have been working with for the past 18 months, give or take. I will say that my supervising attorneys have been incredibly supportive and are also supportive of this effort in requesting a consideration of an alternative pathway to licensure. To say briefly some of the work I have been doing, I have assisted formerly incarcerated folks with cleaning their criminal records, with changing.
Thank you, Billy. Your comments exceeded 2 minutes.
Thank you.
Next public comment from Bohan.
Hi, good morning to all members of the commissions. My name is Bohan Chen, and I have been a provisional licensed lawyer since January 2021. During my past 17 months of the supervised practice, I have worked over 1,500 hours and over 100 cases under licensed attorney practicing public interest law in the family law, domestic violence, employment law, government benefit, and eviction defense. Over this period, my legal duties has been focused on the following area: initial client intake, drafting complaints and answers, researching discovery, motion for default judgment, trial appearance, and providing legal advice. As a PLL, I have an excellent opportunity to learn all basic law strategies with my supervisor and then practice more and more cases in real life. I have substantially involved as a legal practitioner since January 2021. I believe my past 2 years of experience as PLL have resulted in my ability to practice law as an attorney completely. I'm confident in my legal skills and knowledge, and I'm proud of my contribution to the whole community and all low-income communities. Therefore, I respectfully request that the Commission create an alternative pathway to licensure for all 2020 PLLs. It will be essentially not only for all 2020 PLLs, but also for the whole communities in the state of California. Thank you for your patience in listening to my comments. Thank you so much.
Devin, we have been at this almost 30 minutes now. There are 3 additional hands up, it appears. And so I'd like to, those will be the last 3 public comments. I encourage folks not to repeat points that were already made by previous speakers, if at all possible. Thank you.
Next public comment from Wan Song. You've been given the mic.
Good morning, Blue Ribbon Commission and attendees. My name is Wan Song Dumarie. I've been practicing as a provisionally licensed lawyer for 1.5 years. I'm representing clients in court every week. As a provisionally licensed lawyer, I have litigated, propounded, and responded to discovery, researched and analyzed law and complex issues, including in the cannabis industry, advised clients, negotiated settlements, drafted motions, stipulation agreements, other legal documents, analyzed contracts, written letters on behalf of clients, and more. During my practice as a provisionally licensed lawyer, I've built a network of associates such as attorneys, judges, clerks, mediators, etc. We as PLLs are members of the legal community. We are not seeking to abolish the bar exam. We are not saying that it does not have its benefits, but we are also not ignoring its limitations. What we are saying is that with the institution of the PLL programs, we have addressed one of the elephants in the room, which is that the bar exam is not a catch-all be-all, nor is it a one-size-fits-all. We PLLs have proven our ability to learn the law because we stand here before you with a JD after proving minimum competency semester after semester, year after year. The PLLs have proven that we not only possess the minimum competency to learn the law, but also minimum competency to practice law, and both are needed to be an effective lawyer. Additionally, this is evidence that we exceed any abilities or skills that the bar exam seeks to test. So in closing, as lawyers, we pride ourselves on being grounded in logic to reach reasonable conclusions. To require the bar exam to prove that we are competent to practice law after we have practiced law for 2 years, it is as logical as testing a runner on his ability to walk. We are requesting to bring the PLL program, which arguably has proven to be more successful than anticipated, to a logical conclusion by allowing an alternative pathway for licensure for 9.49 PLLs. Thank you.
Our last public comment from Jessica.
Good morning. My name is Jessica Juarez. I would like to thank the Blue Ribbon Commission for the work that they're doing to advance alternative pathways to licensure. As the others, I am incredibly grateful that the provisional license was extended. I respectfully request that the Commission create an alternative pathway to licensure for all 2020 PLLs as a pilot project. I work as a PLL full-time for a nonprofit organization in San Francisco. Our organization mostly represents seniors and those with disabilities. I have personally completed over 2,100 hours in just eviction defense thus far. As a PLL, I have been able to do client intake, propounded and answered discovery, conducted depositions, stipulation agreements, mandatory settlement conferences, done reasonable accommodation letters, and countless other duties. I am also a native fluent Spanish speaker and have been able to help more clients because of it. My experience as a PLL over the last 2 years has resulted in my ability to do ethically and competently practice law as an attorney. With the extension of the provisional license, this is clearly a sign that the court has faith in our work and the positive impact we have had on the state of California. I waive the rest of my time and thank you.
Okay, this will conclude our public comment. I want to thank all the members of the public for the comments, an important part of our process and very much appreciated. I believe we have some minutes from prior meetings that need to be voted on. Let's go to the minutes posted from March 2nd. Can we do a roll call vote?
I believe we have to have someone bring the motion.
Can we do them together? Or do we have to do them separately?
You can do them together. Just get a motion for both of them.
I think there's three.
There's three. Oh, I'm sorry, all three of them.
Can I get a motion to approve the minutes from March 2nd, April 6th, and May 5th?
So moved.
Is there a second?
I'll second.
Thank you. Robert, is that sufficient to move to a roll call vote?
Yes, I'll call the names now. Bakshian,
Approved.
Boyd,
Yes.
Chan, Evans, Dugan,
Approved.
Harrison,
Yes.
Dr. Henderson,
Approved.
Lynn,
Yes.
Montez,
Yes.
Reeser,
Approve.
Rodriguez,
Approved.
Scavalletto,
Yes.
Silverman, Spencer, Williams.
Approved.
My name wasn't called, but I approve.
Oh, I'm sorry, Gardena.
Okay, with that, let's move to the business agenda. We have a presentation that we're going to go through, but before we get there, Audrey, I think you were going to walk us through kind of a review of what was discussed and the framework from last meeting. I think that would be helpful just so everybody's on the same page. Then we'll walk through the assessment, and we have some presenters, and then we will continue the dialogue.
Yes, so I want to sort of go over what we talked about last meeting, and then maybe get to some of those critical inflection or decision points. And then, yes, we'll move to our presenter. So let me share.
Audrey, I do want to do that. I just want to, I don't want to spend too much time on those decision points and keep our presenters waiting. I'd like to go through them so everybody knows what they are, maybe short conversation on them, get to the presentation and then continue. Does that work?
Sure. So maybe I'll go over, I'll preview what we're going to circle back to on our key decision points, and then we can let in the presenters.
I think that would be most helpful.
Okay, that sounds great. Okay, hopefully everyone can see my screen. Zoom is telling me you can. So I'm going to go through some of the key inflection points for today. Last time we met, we went over this framework quite extensively, pausing a bit on the assessment part, which is why we've brought in our speakers today to sort of go back over how assessments could work in a non-exam pathway. So this is just, and this was posted as well again, what we talked about last time and what we're going to continue to tease out today. And these are sort of the critical decisions, and I've put them out as plainly as possible. Key one, does the non-exam pathway begin in law school? And discussing that. Again, going back to California law schools, the experiential education curriculum, looking at requirements, looking at assessment. Is there a post-law school requirement? What is it? And then what we do as the state bar to accredit that pathway for California law schools. So these are, again, this is just a preview of what we're going to circle back to and tease out later. Decisions, this is what I'm calling decision 2, decisions about law schools. Is the pathway open to all law school types in California? Is the non-exam pathway a separate curriculum that branches at some point from the exam curriculum? And is the pathway limited? We talked about this last time. What would be the criteria to limit the pathway, at least at first, in which students can participate? Is there a supervised practice component to a law school non-exam pathway post-law school? Again, very plainly putting it out there today for us to decide. And then how does that work? If yes, how does that work? How are the supervisors supervised? How are the applicants matched? How do we ensure that we have enough supervisors for the need? What is the right number of months or hours? And then, yes, assessment, we'll move on to that. And then I just want to, what I'm calling decision 4 for out-of-state law school applicants and attorneys. Should there be a non-exam pathway for out-of-state law school applicants? And what should that be? Should it be supervised practice? Should it be some sort of LLM or equivalent units to what we're doing for California law students in experiential education? Should it be some sort of transcript review, demonstration of meeting California requirements, or should it be something else? So if we get through all of these decision points today, then we'll move to Amy. We'll be talking about reciprocity and what to do about foreign educated attorneys, foreign educated applicants and foreign attorneys. So that is the preview of a lot of decision points. Let me see, I see that there's a raised hand. Emily?
Joshua, I don't know if you want to take questions, but I have one.
I mean, let's go for it.
Okay, so Audrey, in the decision point process, one of the things that I am not seeing, and maybe that's because I know on our framework, it looks like one of the titles already is not exam pathway begins in law schools. So it doesn't sound like we are making a decision about whether or not it actually should start in a law school.
Well, that's what we talked about last time, which is why I have the very first question is, does it begin in law schools? So that's the very first question.
Okay. But I guess my point is on the decision-making tree that you've outlined, which is very helpful, by the way. If the answer to that first question is no, it should not start in law school. I don't know what the decision tree looks like from there. So do we go to, you know, sort of what we're looking at for out-of-state attorneys, like how many hours? That's the piece that I feel might be missing from this decision. So
and Josh, feel free to jump in. But so if the consensus is no, but we need to talk about something else, and maybe that something else is strictly supervised practice, then we move to that part of the conversation.
Yeah, no, I appreciate that question because I think that is timely before we really understand the framework before we dig into each of the items. I don't think it was intended to be all-inclusive. I think that there are so many potential places we could branch out as a group, and we'll just have to kind of walk through those discussion pieces. And as I started the conversation, beginning of the meeting, you know, I hope that we continue to move forward to a recommendation today, but I'm not going to rush a recommendation, and I'm not going to let anybody else rush it. So if we feel like we're have more questions around supervised practice, we'll take that up at the next meeting so that we can hear from all of the different voices. Any other questions around kind of those that framework? That's where the conversation's going to go. I think it would make sense to have the presentation first, and then we'll dig deep into each one of those questions. Audrey, do you mind letting in the presenters and introducing them?
Nope, let me do that now.
Thank you.
Okay. Perfect. Well, I see Debbie Merritt, who, and this is your third time, I think, coming to the Blue Ribbon Commission.
I want to move to California.
It's wonderful to see you again. Do you want to introduce the other two, Debbie?
Yes, I'll go ahead and kick us off and explain how we'll arrange this. I am Debbie Merritt. I'm recently retired from the Ohio State University College of Law. I'm part of a partnership between IAALS, the Institute for the Advancement of the American Legal System, and NCBE, the National Conference of Bar Examiners, to provide research-based insights to states that are considering new pathways to licensure. We know from, I've watched many of these meetings, that you have lots of ideas for possible pathways. And our role is not to tell you at all what to do. Our role is to use the research to show you some options that you might consider, and that might help you structure the rest of your decision. We've provided several handouts, and I will send to Audrey our slides after the presentation, so you'll have those as well. And we're going to proceed in three parts. Here's how we'll go. Danette McKinley will first explain the psychometric guidelines that govern any licensing path, whether it's a written exam, experiential education path, or postgraduate supervised practice. Danette comes to us as the Director of Diversity, Fairness, and Inclusion Research at NCBE. And I know you've heard some of this already in earlier presentations, but we thought it would be helpful to frame the further discussion. I'll then talk about how those principles could help you design an experiential education pathway with particular focus on assessment. And Logan Cornett will close by discussing how those principles would apply to a supervised practice path. Logan is the Director of Research at IAALS and my co-author on the Building a Better Bar study. Now, we're going to address experiential education and supervised practice as two separate pathways, which is how most states have considered them. I've gathered from the last meeting and from the initial discussion today that you might combine the two in California, and of course that's permissible, but we're going to discuss them as two separate pathways so that you have all the options in mind. And I'm going to suggest that you hold your questions to the end because the presentations build on one another, and one of us may answer a question as we go through this. Let me now turn this over to Danette, who I think will share her screen and we'll get started.
Hello, everyone. Thank you, Debbie, for your introduction, and thank you for inviting us to speak about our collaborative work on non-exam licensing pathways. A lot of what is here will also be covered by my colleagues, so I'm not going to dwell too much on any particular topic. I'm sorry that I'm leaving this in this crazy mode, but it's a lot easier for me to see you and to see my notes like this, so please forgive me while I go through this. I'm sure that you've heard of the standards for educational and psychological testing in the past, and this is what guides the way that we think about testing. The standards for educational and psychological testing were developed by 3 organizations: the American Educational Research Association, the American Psychological Association, and the National Council on Measurement in Education. What's important about this is that they have guidelines for several different types of tests, including licensure tests. And that's what we're going to focus on today. This first quote gives us the central concept that we'll be using as we talk about these different paths. Validity is the core of everything, and I'm sure that you've heard that from the psychometricians that are on the commission. This affects the interpretations and uses that we make of results, whether they're from tests or from these other paths. And one way to focus that is to think first more closely about test purpose. The standards provide guidelines for the way that we think about licensing and what the purpose of that is. In this case, licensing is going to help us ensure that those newly licensed lawyers, that the interpretations we make about results say that these newly licensed lawyers are ready to enter practice. Now, you may determine whether that practice is supervised or unsupervised, but it basically is a way to think of how they can safely and effectively enter practice by demonstrating sufficient knowledge and skills. The content then is determined usually by a job or task analysis, and you've already seen several of those. In fact, California has done one of their own. That type of work lays the ground for what you expect to see in any type of path. What are they going to do to develop knowledge and skills, and what should those knowledge and skills be? Another important aspect is defining competence. So I know Debbie is going to touch on this a little bit more, but we need to decide 2 things. What will newly licensed lawyers need to know and to be able to do in order to safely and effectively represent their clients? And then the next cut is, and what are they going to need to know immediately versus what they're going to learn during their experience on the job? Whether we're thinking of an exam or any other type of measure, we need to ensure that we've adequately sampled the content domain. In multiple choice testing, this is fairly easy because you can have a number of questions and they can test different concepts, different skills, different tasks, and different domains of law. When you're looking at these experiential pathways or supervised pathways, you have to make the same consideration that all of the applicants to a path need to be able to have multiple opportunities to develop, to show that they have the skills and knowledge. And what I mean by that is that you wouldn't look at a single client interview, for example, if they submit that. You would want multiple interviews to give them the opportunity to show the breadth of their experience. Another aspect that might affect decision consistency and reliability of output would be supervisor leniency or stringency. You would want to balance to ensure that they've been given the opportunity to overcome any rater differences that might exist. So you introduce another source of error when you introduce supervisors, but there's a way around that. I'm not saying that it's impossible. I'm just saying that means that having something from multiple supervisors is helpful because that sampling will decrease the likelihood that there's any bias in the results. The third consideration is potential bias, and that could be in the selection of what would go into a portfolio or in what they have the opportunity to do in the time that they are either in supervised practice or that they're in educational experiences. That one's a big one because if the domain is not adequately sampled, you have one type of problem, or if there's an interaction between the supervisor and the content, that's a different problem. So problems that can be solved, but just considerations that need to be made. And the last point is that the challenges that are provided are similar for all candidates. When we use multiple choice examinations, we correct for this through equating. There are ways to do this for these other pathways. It's just a consideration that you need to be able to make sure that a particularly difficult client has not somehow swayed the ratings that a candidate received. At the center of all of this is fairness. I use this slide to illustrate that none of us has a particular definition of what fairness is. It's going to have different meanings to different people in different contexts. However, what we use is the technical guidelines that tell us at different aspects how we can be monitoring fair activities. In developing a multiple choice test or even the essays and performance tests that are on the bar exam, there are several aspects of fairness that we consider. I'm not going to dwell on them here because I'm pretty sure that we've told you about them before, but they begin with test development in assuring that we've met the content domain requirements as identified by the practice analysis, in drafting an item review that we are getting reviewers and drafters who are from a diversity of settings. So some are practitioners, some are professors, and all of them have different levels of expertise. In test administration, in trying to assure that similar conditions are provided for all candidates. In scoring and grading, that is probably easiest for multiple choice questions where we review regularly what the statistics are, but for grading, we're also looking at whether or not we're recovering similar scores. And finally, equating is what I referred to earlier when I said that similar challenges are provided for all examinees. I think that similar considerations can be made regardless of the path that you choose to use. Assessment development would mean making sure that the content that you choose to measure is closely aligned, and I'll talk a little bit more about alignment, with the requirements of the job. In rating performance, we need to be sure, and we can, of consistency between supervisors, but we can do that by making sure that we use forms that focus them on what needs to be measured and that there's general agreement on what those ratings might mean. Regular review by bar examiners and scoring of those final portfolios would be where decisions would be made. And so constant monitoring of that process is essential. And monitoring and equating of the entire system would be important. So as things shift or change, you would go back to the beginning and look at your assessment development and ensure that everything is still relevant to the practice of newly licensed lawyers. This is a really long quote, and I'm glad that Debbie said we'd provide this in more detail because I don't expect everyone to read it while we're sitting here. But the standards do have guidelines around alignment. It's just usually associated with educational testing. The way that we think about alignment and licensure is not really that different. We want to make sure that standards and outcomes are related to the test content. So here we're saying we're linking it immediately to a task analysis. In this case, we would probably be looking at curricular opportunities and how they then relate to outcomes in practice. So are there tasks that are provided during the clinical years that align with what we want to measure? And how do we best leverage that by having consistent collection of data and ratings from faculty who are supervising them? That's just one example. We also want to make sure that there's nothing in our measures that are irrelevant to the standards. So you may have had the opportunity to do something really special with a client, but if it's not part of what is typically done in the domain of newly licensed lawyers, we don't want to give that candidate a special advantage that all candidates do not have. So that's something that I think Logan and Debbie will come back to, so I'm not going to dwell on that much longer. I think the most important aspect of fairness here is feasibility. This has several different aspects, but one of them is access. So you already are considering whether or not this starts in law school or whether it would be a different type of path. At any rate, what I'm encouraging is that you consider the opportunity to pursue different paths and what opportunities candidates might have. Are those opportunities similar? Are there differences? How do you accommodate those? The next important aspect is scalability. In the infinite universe of what candidates can do, it's important to consider how best to process any output that would be considered by examiners and by faculty or by supervisors. I believe that you already have a model for supervised practice, and so we would need to consider something slightly different unless it's, as Debbie said, a combination of the two programs. And finally, I think funding is a big concern. The cost should not be dissimilar from the costs that currently exist for the exam pathway, so that it's not necessarily more expensive to go one pathway or the other and have some type of problems for candidates who are not financially able to support that. Here, I'm also thinking too of what might be available in supervised practice, because it means finding work and how a program might be set up to best facilitate that so that all candidates would have similar opportunities. And the last thing I want to talk about is being able to step back and evaluate and adjust. I'm sure you do that with your current bar exam, but we need to look at fairness and outcomes if part of the claim is that this is making more of an even playing field for all candidates to bar admissions. And is there equity and access to the different pathways, or are certain pathways taken up by people with different characteristics than those that sit for the bar exam? I'm not saying that it would be unfair, it's just that a question to consider in examining what happens in the actual implementation. Here I'm thinking about possible unintended consequences of implementing the pathways and how you might accommodate those differences. In summary, I think you've heard this from your psychometricians. The considerations need to be the same for all the paths, including an exam. The interpretation and the uses of scores is what I said here, but ratings or output from whichever path need to be examined, and those claims need to be validated regularly. Ensuring equal access to the paths may be a challenge, but it's something that I think can be monitored and evaluated continually. And then evaluation of outcomes, looking at what happens when these different pathways are undertaken and what those successful candidates do once they are admitted to the bar is part of the essential validity evidence that you'll be able to accumulate. And with that, I'm going to stop sharing and turn it back to Debbie.
Thank you very much, Danette. And I'll get my screen up here. I know so far we've raised more questions than answers, but now we will start to provide some answers. One of the things that struck me in talking with different states over the last 2 years about these options is that the psychometric criteria that Danette discussed and that you've heard from Dr. Henderson and others really do help answer a lot of the questions that we as participants in the system come up with. So I'm going to try to show now how those criteria will apply to designing an experiential education pathway. I wanted to start first with this inspiring picture from New Hampshire. You've all heard about the Daniel Webster program, which is an experiential education pathway. And these are some of the students who are being sworn in as new lawyers shortly before or after graduation. This also is to assure you that there are some answers out there in programs that have already been implemented. And what we're going to show you now are some answers that we have derived from the literature, which is quite rich in both psychometrics and education. If you've heard me before, you know I like 10 steps, and I've got 10 steps again here for designing the experiential education pathway. I'll walk through most of them, and there are more details in the handouts. As I think you already are anticipating, the first step is the same one that you would take in creating a written exam. As Danette has said, you identify the knowledge and skills that constitute minimum competence, along with the activities that newly licensed lawyers perform. You've already done that in the CAPA report, but I'm putting it here because those findings from that report really will help you design a program if you decide to go this way. The next step is to take those skills, knowledge, and activities and to match them up with courses, exercises, client interactions, and everything else in the law school curriculum. Now here, you really want to cast your net very widely at this step. People first begin thinking about courses, and whole courses are important, but you can also think about simulations and client interactions that take place within courses, or even in extracurricular activities like national competitions. Those client counseling and negotiation competitions offer us standardized simulations that students can be assessed in. Let me give you a few more examples about how you can work with courses and activities. You might want to begin, as Oregon plans to with their path, with a set of required courses that match up with the knowledge elements that the CAPA report has identified. One advantage of an experiential education pathway is that you can designate more subjects than you can actually cover during a 2-day written exam. So here and you can also create options for students so that you can encompass more possible practice paths by giving people some options. Here's an example where you might choose 9 foundation subjects that the CAPA report identified that would be required for everyone. And then you might allow students to choose 2 of a list of subjects that are also quite common practice areas for new attorneys, but where people would be allowed some choice. But, and this is the really big point, completing knowledge-based courses is just the beginning of any experiential education pathway. Because in this pathway, students demonstrate their knowledge by applying it in clinics, simulations, and externships. That's one of the strengths of an experiential education pathway. It allows you to test knowledge in action, not just knowledge on a written exam. If you think, so to understand what I mean by this, think of a student who is doing a simulated or a real trial in either trial practice or a clinic. They can't possibly do that without knowledge of the rules of evidence, the rules of civil or criminal procedure, the rules that govern the particular subject matter in which they're litigating. Nor can a student counsel a client on contracts unless they know the basics of contract law. And of course, they will also need to understand the basics of the skills that they're exercising, like trial practice, counseling, negotiation, and other skills. But I want to stress here the fact that the knowledge coverage comes not just in those knowledge-based courses, but in all of these elements of the experiential pathway. Here are the lawyering skills that you identified through the CAPA report. And of course, if you design an experiential pathway, I would focus on those particular skills as the way to include them in your pathway. There's 2 basic options here. You can actually, again, require courses in which the students would learn and demonstrate these skills. Maybe, again, 4 required courses that cover things that all new lawyers should do, and then choose 2 of a menu of courses that might enhance a particular student's skills. I think, though, you will find that a better approach is actually to think about experiences. Individual experiences within clinics, courses, simulations, competitions, and so forth. So rather than design and requiring the courses, you say, here are the things we want students to show their competence at during this pathway. So maybe we want students to complete 4 client interviews or counseling sessions. And the student might then be able to fulfill that requirement from a number of different places. Maybe 1 is done in a simulation, 2 are done in a clinic, 1 is done in an externship or a competition. This type of approach has several advantages rather than just thinking in terms of courses. It avoids debates about whether a particular course qualifies for the pathway. And for those of you who have sat through faculty meetings on whether a course qualifies for something or not, that is definitely something to be avoided. Just as important, it opens up more opportunities for students to gather the experiences that they need. I will add, though, one caveat to this open, flexible menu approach, which is that I do recommend requiring that students take at least one live client clinic as part of this experiential pathway. There are some skills that are very hard to develop outside of the context of working with and interacting in real time with a client. So the clinics provide that, where simulations and externships do not always do so. And clinics also provide extensive feedback and reflection, which are critical for growth for a lawyer. Requiring at least one clinic will also make sure that the pathway is balanced between live client and simulated experiences, which both contribute to validity in different ways. So it's good to have some of both. Moving on now to the next step in creating an experiential education path, the pathway has to provide for ongoing feedback and assessment. This is important for all students, but it's especially critical for a licensing path. We need to give students signals along the way as to whether or not they are succeeding in the path. If not, they may want to withdraw from this path and sign up for the bar prep course and think about taking the bar exam and gaining a license in a different way. Equally or more important, feedback levels the playing field. It accommodates first-generation students and others with little knowledge of the legal system. If you have taught in clinics as I have, you've met students who excelled in trial competitions during their college years. We don't want to set up a licensing path that is exclusively for students who did trial competitions during their college years. All right, so what are we going to do with all of these courses and learning experiences? It's not enough for students to just do these things. We need a form of assessment to be sure that they are, in fact, have the knowledge and skills that they will need to serve clients effectively after their license. The easiest way to do this is to have the students create a licensing portfolio. The portfolio will gather all the evidence, which is then presented to the licensing authority to make a decision about whether or not they are minimally competent. The portfolio will include things like a transcript showing completion of required courses, but I want to stress again that it's not really the passing of those courses that is the evidence in the portfolio. It's a foundation, but we want to look at their knowledge and skills in all of these other contexts. So we will have written work that the students authored during the pathway. There could be video of work in simulations. There might be log books that will document the full breadth of activities. So I'm not going to show you every document I did, but here's all the different things I did during this pathway. It will also include assessments, interim assessments by instructors or supervisors, others who've interacted with the students. And I'll explain a bit more in a minute what we would do with those assessments. And finally, the portfolio should include the student's learning plan and reflections on various parts of the pathway. These are really important pedagogic tools that we don't make enough use of in law schools, but they're also very essential parts of showing one's competence as a lawyer. You need to demonstrate your ability to engage in ongoing learning and also to manage a project. And here the students are managing the project of their own licensing path. It's just as important, though, to think about what's not in the portfolio. A licensing portfolio is not like the baby book of a firstborn child, which has photos of every step and tumble along the way. The students need time to learn in law school. They shouldn't start the licensing on their first day of law school. And they need time, even sometimes, to fail before they become competent lawyers. So although the pathway will require students to produce a certain amount of work, they are free to learn and stumble first. They will choose what to include in the portfolio. There's no requirement that you submit every document, even the ones that did not work out so well. This brings us to the fifth and very important step in this process. The portfolio should be reviewed by bar examiners who decide whether a student has demonstrated minimum competence based on the evidence in the portfolio. Assigning this decision to bar examiners is critical for several reasons. First, it maintains a line between education and licensing. One is formative, the other is summative. Students should be able to make mistakes without fearing that those mistakes in the classroom will taint the whole licensing decision. It also protects professors, especially ones without tenure, from administrative pressure to certify students who the professor does not believe is minimally competent. Putting that decision in the hands of bar examiners, therefore, is essential for making a valid claim that this system certifies only minimally competent attorneys. And it's also essential for reliability and fairness to candidates. Every professor at every law school may have a different definition of minimum competence. Their insights will help the bar examiners, but we shouldn't leave that final decision in the hands of the individuals at those law schools. So what will the bar examiners do with all the material in these portfolios? The keys here are steps 6 and 7, rubrics and training. Now, I hesitate to show you samples because rubrics really should be developed in consultation with the stakeholders who use them. But I know in imagining the possibilities, it's important to get a sense more concretely of how this might work. So we offer some examples in one of the handouts that we sent to you. This, for example, is a universal rubric for many types of documents that could be generated by an experiential education pathway. And here's the bottom half of that rubric. There's a slightly different one for contracts, leases, and other documents that have the force of law. But between these two rubrics, I think one could evaluate just about anything that comes out in documentary form. Now, you might be wondering, though, how will the bar examiners, they'll have this rubric and they'll have the document, but they won't know anything about the law or the facts underlying this particular problem. Well, the resolution to that comes in several forms. If the document comes from a simulation, there will be a briefing packet that gives the examiner the law and facts. If the document comes from a clinic, there will be other materials in the portfolio, such as a research plan by the student that would illuminate some of the law and facts. And there will also be initial assessments of these documents from the professor, the supervisor, the competition judges, who first looked at this document. So the bar examiner is not simply looking at the document, as in the case of grading an exam essay, but is looking at the document with the context of some other materials that have been provided, and that will provide some guidance. Although again, it's the examiner, not the professor or the other initial rater, who makes the decision about that document and other elements of the portfolio. Now, in some cases, the examiner may have to rely almost exclusively on assessments that are made by people in the educational pathway. For example, the examiner won't be able to go and sit in on a client interview with a live client in a clinic. The examiner may not even have time to watch videos of simulated client interviews. That depends on the workload of your examiners. So in cases like this, for some of the exercises, there will be rubrics that are submitted in the portfolio. And the key to this is that the rubric should include very specific points about the student's performance. We don't want a professor to simply say, oh yeah, it was a competent interview, good job. We want the professor to say, did the student explain their unlicensed status? Did they explain the attorney-client privilege? Did they provide contact information? Did they identify the legal issues? Did they state the law correctly? And so forth. If we have that kind of detail, then it will be possible for the bar examiner to make a decision about the competence in that area. But only if, as Danette pointed out, we have multiple pieces of evidence. We don't want just one client interview with one rubric filled out by one person telling us whether or not the student is competent to do an initial client interview. We want to have multiple performances by the student in multiple different contexts and with multiple different raters. And if we can achieve that, then we can produce a portfolio that is more reliable, that is more fair to the students, and that will support our licensing claim. Training is important to complement the use of these rubrics. It's important for the first line raters, the faculty supervisors, and others who may assess students during the pathway. It's also essential for the bar examiners who will be dealing with these new types of materials. We want the training to focus on at least two things. One is the types of bias that can affect these sorts of ratings and how one can deal with that. And also the use of the rubrics themselves, which will be new materials for both the professors in law school and for the bar examiners. And then for the bar examiners, the training should also be used to help develop consensus on what constitutes minimum competence. I suspect that your exam graders engage in calibration sessions where they look at model answers to a performance test or essay and discuss how they would rate it and resolve differences among them. The same sort of process would occur with a portfolio review. You would have some sample portfolios that the bar examiners would review to talk about differences in how they approach the rating. And that brings me to an issue that we didn't discuss actually in the handout, but is an important part of any licensing system that depends on portfolios. So what do we mean by minimum competence in the context of a portfolio? Or in other words, we might say, how do you set a cut score that distinguishes a portfolio that has evidence of minimum competence from one that does not? Well, there are three general approaches, one that I don't recommend and two that are good choices and that you could choose between. The one I don't recommend is trying to judge the portfolio holistically. You could simply say, well, let's just read it through and see, does it feel like minimum competence or not? These portfolios will have too many pieces of information in them for the brain to make a good holistic judgment. There's too much risk of subjectivity and unreliability. A second approach, which is feasible, is to assign points to various parts of the portfolio and then to use a standard setting exercise to agree on the point value that signifies minimum competence. That's most like grading a written bar exam. It offers reliability, and it also allows candidates to compensate for poor performance in one area by a better performance in a different area. The third approach is one that I call the building blocks method. It's a variation. Well, it doesn't use points directly. In this method, the examiners would identify components or building blocks that must appear in a portfolio, together with a minimum standard for each of those components. So you could actually use points within each of the components, or you could have a somewhat more holistic review of each component. And then if the portfolio demonstrates competence on each of those building blocks, the candidate would pass. There's many variations of these last two methods, but something along one of those two lines would be a reasonable way to judge the portfolios. I'm just going to display here the final three requirements for a sound licensing system. Transparency, critical. It means that students and other stakeholders know what those rubrics say and what the other criteria will be that will be applied to their performances. There should be additional licensing requirements in the system, such as character and fitness review, potentially passing the MPRE, which some states are looking at as an addition to the experiential licensing path. And very important, periodic review of the system. Is it working? Is it accomplishing what you want? Does it fit with the criteria we've discussed? Let me now just very quickly run through, as we finish, how this type of licensing path could achieve the 5 criteria that Danette laid out. Validity of the pathway rests on starting with that practice analysis, matching the courses and experiences, leaving the final decision in the hands of bar examiners, having those additional licensing requirements like character and fitness, and periodic review of the system. Reliability rests on having a portfolio with many elements coming from simulations and live client representation, leaving the final decision with the bar examiners, and making extensive use of both rubrics and training. Fairness rests on a portfolio, again, with many elements, so a student isn't disadvantaged by one particularly harsh grader or advantaged by a lenient one. Frequent feedback throughout the system. Again, those rubrics and training, which will focus the examiners on the essential elements of the portfolio, and transparency, so that the students can track what they need to do in order to succeed. Alignment, again, starting with that practice analysis, mapping the courses onto the analysis, thinking about additional licensing requirements, and periodic review. Finally, let's talk about that big question of feasibility, right? All of this sounds like a huge amount of work, and it is. But we have talked already about a few features of the system that ease the workload and aid feasibility. That is casting a wide net within the curriculum for the experiences that will count in the pathway, using rubrics, using training, both of which after their people adjust to them will make more efficient the review of both professors and of examiners. But still, it's a big job, right? So I want to show you an interesting comparison between the California ABA accredited schools and the University of New Hampshire that has adopted this kind of pathway. I'm sorry that I don't have data on the California accredited schools. I don't think that's published. There's any public source for that. But when I looked at the California ABA accredited schools, I was really intrigued to find that all but one of them have a better student faculty ratio than the University of New Hampshire. All but one of those schools has more clinic seats per student, and all but two have more simulation seats per student. So it's not impossible to use a curriculum in California to create an experiential licensing path, because these resources are available even before we start thinking about any additions that we would want to make to the path. The harder question, I think, is on the examiner side, and I do feel for the examiners who are listening to this presentation. California has 66 times as many candidates as New Hampshire every year for admission to the bar, and that's a huge step up in scale. It is true, however, that California has 54 times as many active attorneys who might serve as bar examiners to review some of these portfolios. But I don't want to understate the difficulties of scale in California. It is difficult to organize something on a scale like this. Not impossible, but it would be difficult, and it takes some thinking about the resources that are available. So to close, let's just think about resources. We don't want this system to cost more than an exam licensing system. But the exam licensing system has quite a lot of costs that we don't always remember because we're accustomed to them. All the ones I've listed here, the first 5 are the costs to the state, the court, or the bar examiners, whoever you want to call that pot. And then there's the big one, that one at the bottom, the costs of preparing for the exam, which you already know from previous presentations is very, very heavy for current students and candidates in California. So one of the questions when thinking about an experiential education path is, can we take, I guess you could put this question 2 ways. One is, would students who are pursuing this pathway be willing to pay somewhat more because they will be licensed when they graduate? They won't have to pay for bar prep or take those 2 months without employment. The other way to put it is, would the profession be willing to bear somewhat more of these costs? The written exam pushes, for a variety of reasons, costs onto the candidates. Would the profession be willing to bear somewhat more of these costs in order to create a system like an experiential education one? And just to close, these are the benefits of the pathway that you could get following the 5 criteria that we've laid out, and to weigh against the costs. It does provide very strong preparation for practice, probably more than the general elective curriculum at law schools. It can make a strong licensing claim based on all the knowledge and skills that are needed. It can lower the cost for candidates who are licensed after graduation. And it may be the single best way to increase access to the profession, given that lowering of costs. So I will look forward to questions on this portion, but first, let me ask Logan to take the stage to talk a little bit about supervised practice.
All right, great. Thank you, Debbie. Hopefully the right screen is shared. Someone will scream at me if it is not and let me know. So yeah, I'm going to share some guidelines and principles, much in the way that Debbie did, for designing a supervised practice pathway. And you'll notice, of course, that there is a fair amount of overlap, right, in the guidance that Debbie just discussed for the experiential education pathway, which you might expect given the similarities in the material and the broader approach. So I won't linger too long on points that have already been discussed, but I do think that each component bears mentioning in the context of the supervised practice pathway. So let's dive in. And this is just sort of a recapitulation of what Danette went over, but the primary goal, of course, of any pathway to licensure is to ensure that those who are admitted to the bar meet the criteria for the minimum competence to practice law. And it's critical, as already described in detail, that any pathway satisfy these 5 criteria for sound assessment. So we can look to insights from the academic literature, including that from medicine and other professions, for guidance on how to achieve this. So the literature that we have reviewed points to 10 broad guidelines for designing a supervised practice pathway. And I've sort of thrown all of these onto this slide, but I'm going to go into each one of them in a bit more detail. So first, the validity of any licensing system, of course, rests on clear evidence-based definitions and understanding of what level of competence is required for practice. Of course, in the context of law, that means understanding the tasks that new lawyers need to perform and the knowledge and skills and abilities needed to perform those tasks. So there have already been a number of recent studies that provide these empirically based insights into minimum competence. As has already been mentioned, we did the Building a Better Bar study, Debbie and I, which identifies the competencies, or what we call 12 building blocks, that new lawyers and their supervisors associate with entry-level practice. There is, of course, also NCBE's practice analysis that provides similar data on minimum competence, and then the CAPA report that offers that state-specific, California-specific look at competencies that new lawyers need. The next component then is gathering rich data for each candidate. Debbie talked a lot about this, but a system of assessment that's built on supervised practice should collect information from multiple sources, right? So supervisors, peers, staff, the candidates themselves, and perhaps even clients. It should measure a range of relevant knowledge and skills. So it should have the capacity to explicitly measure each of those elements of minimum competence. Should use different formats, right? So different modalities of assessment. And it should also rely upon multiple observations. And these materials for assessment and final licensure decision-making can then be compiled into a portfolio. The next component here recognizes that candidates for licensure need opportunities to grow and learn from their mistakes during the supervision period. So supervisors should provide formative assessments throughout the supervision period aimed at giving feedback so the candidate can grow and improve. And this is distinct, of course, from summative assessments, which are used for that, final decision-making about competence and about licensure ultimately. These formative assessments benefit both the candidate and the employer because the candidate's growth and improvement, of course, benefits their own development, but it also benefits the employer in terms of the quality of the work that they are able to produce. Formative assessments also create space for critical or negative feedback, which can be challenging for supervisors to deliver, right? Research suggests that supervisors are more comfortable providing negative feedback when they know that the candidate is going to have a chance to improve as a result of it. And then finally, formative assessments and the repeated practice that is associated with growing from formative feedback support the development of expertise. So the next point here is that while supervision and formative feedback occur in the workplace, that final certification should not, much in the same way that it should not occur in the law school in an educational or an experiential education pathway. So in other words, an independent decision maker or bar examiner should be the one to make that final determination. And this approach provides a number of benefits. So it reinforces the acceptance of supervised practice as a learning opportunity, right? So candidates can focus on learning and growing during that supervision period. Relatedly, it supports the focus on formative assessment throughout the supervision period. It improves the credibility of the supervised practice pathway, right? So trained examiners making that final determination rather than supervisors. And then finally, it allows for the reality that some candidates are going to need to change supervisors during the supervision period. It is critical also, of course, to make sure that supervisors and examiners are highly credible. So in terms of supervisors, this means that they should be licensed lawyers in the state. They should have a demonstrated interest in training and or mentoring new lawyers. They should have a clean disciplinary record or have demonstrated clear rehabilitation. They should have at least 3 years of experience in practice, with at least 2 of those years being in the state. We should be cognizant that seniority is not equivalent in every case to better supervisory competence, right? So lawyers in some areas like government agencies and small firms take responsibility for client matters really early on. And new lawyers may be more familiar with newer practice methods than senior lawyers. So finally, DEI considerations are, of course, critical. We need to make sure that there is a diverse pool of supervisors engaged in the pathway, and that these supervisors are positioned within organizations with a demonstrated commitment to DEI efforts. In terms of examiners, this means that they should have experience practicing law in the state. And for examiners, a longer period of time and practice may be appropriate. For example, it may be appropriate to require 5 or 7 years of practice to become an examiner. Examiners should devote only part of their time to portfolio review, right? They should not be full-time examiners. They should continue practicing or teaching law. And this helps them, stay grounded in the profession, which improves credibility. And lastly, again, DEI is a critical component here. The pool of examiners should be diverse in terms of, demographic characteristics, geography, practice areas, practice settings, and organizations. Another key component of supervised practice pathway is training for supervisors and examiners. And it's critical to note here that it's not necessary or even desirable to remove differences of opinion across individual examiners or supervisors, right? It's a strength, actually, of this type of licensing system that it can capture nuance and differences in approach. However, training is still, of course, very important and very valuable. So some potential topics for training can include the purpose of the assessments that are being used, how those assessments are scored, tools for avoiding implicit bias, strategies for providing constructive or critical feedback, and approaches for informing candidates that their work does not demonstrate a sufficient level of competence. An assessment system will, of course, only work if it is designed in a way that facilitates its use, right? In other words, it needs to be user-friendly. So this means involving stakeholders in development. And stakeholders here include supervisors and examiners, of course, but also new lawyers. And also worth noting here is that there may be some value in looking to best practices in performance review and folks with that kind of expertise to inform development of the system. Ultimately, developing and implementing an online system for storing portfolio documents, assessments, and communications may be ideal. That would allow for things like broad impact tracking across the state, as well as a hub for individual supervisors, examiners, and candidates to interact and share materials. But at the same time, it may be really costly and time intensive to create and train people to use a system like that. And that can be especially problematic early on when the system may be frequently changing and adapting based on feedback and use. So for that reason, a paper-based or lower tech solution may be best for those early stages. Also, of course, absolutely vital to design high quality tools for feedback and assessment. And some recommendations that we have for good feedback and assessment tool design include tying feedback and assessment to specific components of competence, operationalizing those components with prompts that prompt recall of behaviors that signify a candidate has achieved a certain level of competence. So for instance, in those rubrics that Debbie showed just a little while ago, they provided some detail about what behaviors and actions indicate the different levels of mastery, right? Numerical ratings should be avoided assessors often find it difficult to assign low numerical ratings, and those numerical scores don't provide a ton of guidance for candidates on what it is that they're doing well and what they need to improve on. I'll note, though, that those numerical scores can sort of be built in on the back end for use by examiners. In addition, it is important to encourage narrative feedback, right? So this is where candidates receive individualized, detailed information about where they are excelling and where they should focus their efforts to improve. And lastly, we need to make sure that that feedback is actually shared with the candidate. I'll also note here that it's important to employ a variety of rubrics and other tools for feedback and assessment. Another essential component of a supervised practice pathway, or any pathway, is transparency, right? So specifically, candidates need to have access to information about who it is that's going to be evaluating them, how they are going to be evaluated, and the criteria that they must satisfy to successfully complete the pathway. In addition, transparency helps to create a system that's open to criticism and open to improvement. So that leads us into the final piece of guidance for designing a supervised practice pathway, and that's building in evaluation and adjustment, right? No assessment system is created perfectly from the outset, and needs and expectations within the profession change over time. So assessment systems must be flexible and able to evolve over time. Evaluation may involve elements of formal evaluation, so including things like process evaluation. So, looking closely at how the structures are being implemented and whether they're being implemented as intended, what's working well and what's not working so well about that implementation. Could include elements of outcomes evaluation, of course, so understanding whether the system is achieving its intended outcomes, licensing competent lawyers. And then finally, perhaps elements of impact evaluation. So understanding whether the system is achieving its broader systemic goals in terms of things like increasing equity in the licensure process, increasing diversity and inclusion in the legal profession, and so on. Relatedly, and perhaps as part of that formal evaluation process, it's also critical to create these regular opportunities for feedback from stakeholders on the assessment system that's in place. So stakeholders that may have valuable feedback include, of course, supervisors, examiners, and candidates, but also practicing lawyers, judges, legal educators, law students, recent grads, clients, and members of the public. So that is my sort of quick and dirty version of what we should think about when we're designing a supervised practice pathway. So I'll turn it back over to you, Debbie, to finish us up.
Thank you. And I have nothing else to add other than that we're happy to answer any of your questions. And I think we'll also stay around for the rest of your meeting. So if you'd rather get on to other discussion, and we can answer questions later, whatever works best for you.
I think it would make sense to take questions specific to the presentations now, and then we'll go back to the framework that we started with. So I see Susan has a question. Why don't we start with her?
Thank you. Thank you for all the helpful information. Let me start by just asking for some quick clarifications. I noticed that in the presentation, you suggested that you would recommend a live client experience be included in a non-exam pathway. And also later in the presentation, you had some information about ABA seats as compared to the at least California ABA schools as compared to New Hampshire. And I'm curious about sort of what definitions were used in that ABA assessment, that there are certain numbers of seats and for simulations. And I'm wondering how these two things compare as well. When we talk about requiring a live client component, what does this data source and what do these definitions suggest for feasibility?
I can't answer directly what the definition is that the ABA used. That those data come from the ABA survey that law schools fill out every year. So it's what law schools claim they had in number of seats in clinics and simulations. And I think, you know, a live client clinic is not something, I did not put it on there as a absolute because I don't think that the research, the licensing research suggests that it has to be. We license people now with a bar exam and they may never have met a live clinic. I do think it's highly recommended because in order to, one of the strengths of the experiential education pathway is making really a deeper and stronger claim about competence than the written exam can. And part of that deeper and stronger claim is that this is somebody who has already shown that they can interact with clients, who can deal with all of the stresses that clients bring and so forth. And since we're talking about just one clinic, not a full clinical pathway, I think that it would be quite feasible from what I've seen of the data for the ABA accredited law schools to fulfill that just starting tomorrow. It depends, of course, on how many of your students choose this pathway, but I suspect that there will always be a significant group of students who will stick with the bar exam, partly because that's what they're used to, and partly because they want the portability to other states, even though I know how wonderful California is, but still some of them may choose that. So if you have, New Hampshire has 25 students a year, and that is a school, it's not a tiny school, it's about 540 students in a class, I think. Even if you had 50 students in a pathway or even 75, I suspect that the seats are there at the schools that have answered the ABA survey.
Neil?
Yeah, hi. Thanks for these terrific presentations. I'm curious, do you folks have any estimate in terms of either the experiential pathway or the supervised practice pathway in terms of how long these pathways may take post graduation from law school? And then my second question is vis-a-vis the experiential education pathway with various portfolios that would have to be created. How do you, I hate to ask this, but how do you prevent cheating in that kind of system?
Okay, so first, the length, that's the easier question, right? The experiential education pathway, as other states are envisioning it, ends at graduation. The student is literally sworn into the bar the day before, the day after graduation. Okay. If you decide to combine it with a supervised practice, there is this possibility of melding the two, then you could require some additional experience after graduation. In the supervised practice pathway, there are examples that range from, I think it was 360 hours that Utah required in 2020 with their emergency pathway for the pandemic. I can't remember what your 1440 group is, the PLPs who
it's 300.
Oh, no, not them. These are the ones who didn't get, who are in the bar in the cut score gap.
1390, the 1390 to 1440, right?
Right. And Oregon is about to create an emergency supervised practice pathway. So you will have yet another model. These are for people who took the February bar exam in 50-degree rooms. And so Oregon is compensating for those who didn't pass. And I've actually working with them to create all the detailed rules about that pathway. That pathway is going to be 1,500 hours, but that's a very high number in part because these are people who failed the bar exam and it's a compensation to them, but they want to have more proof. I would generally peg it at something like 750 hours.
Okay.
If I were going to say, based on what I think would give you the amount of observations to give reliability to the system, fairness, and also make a valid claim. Oh, I'm sorry, cheating. That's right.
Yeah.
I was cheating on answering that question. Law schools already deal with cheating. We have students who cheat, and when they cheat, we have honor code investigations and so forth. So those would obviously apply to this experiential education pathway. I would think that anybody who cheated then at the kind of next level by including something in their portfolio that they had not done, I guess I would first have the supervisor or professor sign off on it, right? So you would have that catch against the cheating, and that might actually be sufficient to remove the kind of cheating that you're thinking of. I'm desperately trying to think of all the different ways one could cheat in this type of system. It's hard actually, right? Because you can't send somebody else to do the simulation for you.
True.
To
but if say, for example, one of the portfolios is a writing assignment, right?
Right. And with writing assignments, one of the things that we addressed this at more length in the handout, one of the questions to address up front is whether or not you want absolutely independently authored samples, and there are ways to do that we talked about, or if you want some to be collaborative. But I would basically have a sign off. Any of these assignments would have been done in the context of a clinic, a course, or a simulation. If there's cheating behind the scenes that the professor wasn't aware of, we deal with that in the usual cheating context of law school. I find it difficult to think that actually over the course of 2 years in this licensing path, that somebody who's cheating wouldn't be caught somewhere along the way. But maybe I'm too optimistic about human behavior.
Thanks.
Danette, I saw you had a hand up. Did you want to jump into the dialogue?
I was just going to jump in and say, generally with performance-based sampling, it's a little bit harder to cheat. So even if you hired somebody to do your writing for you, some other aspect of the portfolio may show a deficiency that sort of offsets that you got somebody to write for you. You know what I'm saying? I think that was the part of domain sampling that I was saying was critical, that you'd have enough opportunities to be able to make some pretty consistent judgments about performance.
Okay. Emily?
Thank you so much. I really appreciate this. Was very, very helpful. I guess along the cynical line of Neil, I can envision, Barbary, Themis, Kaplan saying, hey, we are licensed portfolio experts. You should pay us and we will help you develop your licensed portfolio, whether it's in law school or after. And I don't mean to pick on Barbary, Themis, and Kaplan, but just thinking about sort of the commodities that may exist with this. So in just thinking about kind of how a student that's either going through law school is putting this portfolio together, or on the supervised pathway or the combined, I think, and I apologize, it was either you or Logan who mentioned having a computer system or something that would be available. I think it was Logan, to be available to like kind of upload all of this stuff. Do you envision that would actually, it would be a process like that the examiner would be able to hold pieces and that they could put it in, and there would be maybe somebody that at the examiner at the state bar or something that could field questions about that? Or is it really a sort of end of the term or end of the period time? And maybe we don't know, but I'm just thinking about the people that are trying to put all of this together and saying, if I have the resources, I would pay somebody to tell me what to do. And maybe that's okay.
No, those are excellent questions. I don't think that would be okay for Barbary to, and it's one I'd never thought of, Barbary advising you on your portfolio. But I think it's a question of whether the law schools will do a better job than Barbary could. And I think that this is an area in which law schools will. That, I'm not saying every professor in every law school will do a good job of giving feedback to their students, but we're talking here about courses, simulations, clinics, even a doctoral course that has a lab component where the professors have already shown themselves willing to give feedback to students and are often very, very engaged in that. So if the law schools are doing a good job with that, then there's really no place for Barbary to step in. But it would be interesting to see, Barbary now owns West Academic, which is the publisher for law school casebooks. So I don't know if there's some wild way in which this is all going to come together. other thing I would say about, oh, this is kind of a combination of your two questions. And then I see Jeanette has her hand up and I'll ask her to fill in here too. The one question that I did not mention, one issue I did not mention is whether or not you want bar examiners to review the growing portfolios during the 4 semesters of the upper level in law school. New Hampshire does that, and I think it's very helpful because it does give the students more feedback as to whether or not they're on track. It can also be set up in a way that it doesn't increase the workload of the bar examiner, because once you've reviewed a document and said, yep, this one qualifies, nobody needs to review it again. That's the approach we're taking in Oregon with the supervised practice pathway. So you kind of raised, I wasn't sure if you were quite asking that, but I do think it's not essential. Feedback can be given within the law school, and there might be, just as most law schools now have bar support faculty who help students prepare for the bar exam, there might be bar support faculty who meet with the examiners and who have a sense of what's going to be required in these portfolios and would be advising students as they go along. And in terms of online, this is also just a question of, you can start with a paper-based system and just have people collect things, even in a literal old-fashioned paper portfolio, and send it to the bar examiners. You can do a kind of rudimentary online where everything is in paper, but then we just upload it to some protected site. Or you can ultimately, once you're comfortable with the contours of the system, have something where things can be recorded online in a protected site. So even every evaluation that I'm doing, I'm feeding it right into the system. Jeanette, do you want to jump in here with other thoughts on that?
I was going to say a little bit about portfolios and teacher certification and my experience in medical licensure. So I'm sure that there are ways to cheat that we haven't thought of, but one way that I will talk a little bit about was that we actually eventually made the communications rating scale public. We published papers, we put it up on websites, we put it everywhere, so that even when coaching was occurring, they're learning skills that they're going to need to have for patient contact anyway. And I don't know if that's necessarily a bad thing. I guess the problem there is whether or not everyone has the same opportunity to access that training. And I think that to the extent that these are transparent, made public, you're sort of avoiding that problem by saying, look, here it is. You don't have to go to Barbary. We're telling you what the expectations are and setting that out in advance. And for teacher certification portfolios, I believe there are a number of measures in place to make sure that the materials that are accepted are consistent. And I do know that videos are one aspect of that, so that the person that you're grading is they have to line up. You can't sort of send somebody else for that. So there are ways around it. It's just a challenge that you have to consider. So thanks for the question.
Donna?
Thank you. So this is a question for Debbie. I may have missed it in your presentation, but I heard in the very end of your response to Neil, and then again in your response to Emily, talking about that the experiential pathway would be, you're envisioning this in the second and third year of law school. So I just want to wrap my arms around a little bit. So the first year is sort of the same regardless of what your path is going to be. And then the second year is, are you envisioning a mix of coursework and simulations and clinics and externships, or there's no sort of traditional courses that would be happening second and third year?
The reason I refer to it, the pathway in the second and third year, is because I think students would need time to think about whether they wanted to enter this pathway. Some of them, of course, might enter the pathway even if they also want to take the bar exam because they think it would be a good education, and schools will have to figure out whether they have enough room for that. The courses that are completed in the first year would still, though, count towards the pathway. If you think about those required knowledge courses, a lot of them are covered in that first year. After the first year, I think there would be students in the pathway whose course load would not look very different from some other students, because it is a mix of the regular courses. There's not going to be a separate business associations course for the pathway and for the non-pathway. And many of the courses that the students would take in the pathway are ones that their classmates would elect in any event. And the simulations, the pathway would require a certain number of experiences, whether, clinic and then experiences that come from various simulation courses and elsewhere. But again, these would be courses that, at least as I envision it, to make it the most flexible for everybody, would be open to everybody in the law school. So if I'm teaching client counseling, some of my students are going to be in the pathway, and they may use their videos to submit to the bar examiner, and I may be asked to complete a rubric, a special one for those students, but other students may be simply taking the course for their own education and development.
And then for Logan, the supervised pathway. So Debbie had mentioned at the beginning that that California may be unique in thinking about the supervised pathway as part of or an extension of the experiential pathway. So for those who are just doing a supervised pathway without the experiential piece, is what is envisioned in other states, or what you think might make sense, is at the end of your law school career, you graduated from law school, instead of taking a bar exam, you are opting entirely into this supervised pathway with 750 potential hours of supervised practice, but that there aren't any requirements in law school, and therefore it could apply equally to out-of-state and in-state students.
Yeah, I mean, that sounds like the correct assessment to me. Do you agree, Debbie?
I do. I think Logan's calling on me in part because I've been literally writing these rules for Oregon for their supervised practice pathway. I think what I would recommend is that anyone could enter the supervised practice pathway at any time, so that a graduate could even enter it after failing the bar exam if they want to try and improve their experience that way. During the pandemic, there were some states that said, no, we don't want to do that. If you failed a bar exam, that means you have to keep taking the bar exam. I would say, let's try a different pathway if the person can prove their competence through supervised practice, which will be at least as rigorous as the bar exam. And I don't see any reason why a student would have to decide earlier in law school to take it. There was some discussion in Oregon about whether to do supervised practice, people would have to take certain courses in law school, such as evidence, for example. Even though I teach that course, I don't know why that's always comes up, but, and I would say probably not, because that can also be filled in with CLEs and other types of education. I don't think we need to assume that beyond the requirements of getting a JD, which are fairly uniform from school to school, that there are any particular courses that you would have to have for a supervised practice pathway.
Great.
And I was just going to jump in and say, remember the other side of this, where there are educational requirements regardless of the path that you take. So graduating from an accredited school or an approved recognized school is part of that. So keep in mind that that side of it may accomplish the goal that you're talking about.
Thank you.
Emily, did you have an additional question?
Yeah, and I'm not, I apologize, I'm not sure if it's a question, but I will just say that Debbie, based on, and I know this is all rough numbers, but if it was 750 hours and they could start after graduation, I think we're talking about an endpoint of October of that same year, whereas now in California, bar results come out in November. So the attractiveness for somebody who might be able to start working earlier than being sworn in December or whatever. I mean, again, all of that is to be worked out. But I guess I'm wondering if everything is the same up until the point that somebody graduates and someone could take the bar exam or do the supervised practice. Could they do, I guess, both? Or should if we're thinking about this option, should we as a commission decide that no, the bar exam, I mean, hopefully the bar exam can be moved up and not in July, but if that's where we are with July and we still are waiting for results in November, do we use that timeline as a way to say the supervised practice can be before or after that, or does that matter? And so I don't know if that is a question for you, Debbie, or if that's just a thought for this group, but to think about the timing of each of these paths.
Yeah, I had in part mentioned 750 hours with the idea that people would be licensed at about the same time as others who took the bar exam, because people often don't start right after they graduate, and they may not be able to get in 40 hours of work that would count towards a supervised practice pathway. So in general, that's the kind of idea that I was reaching towards. I think, it depends in part on what you adopt as your bar exam, if you go with one of your own or if you go with Next Gen. But in general, I would definitely recommend to a student, don't try to do both at the same time. That, if you have a job lined up, you might study for the bar exam, take the bar exam, and let's say it's still in July. Go to work right away. If your job is going to qualify for the supervised practice pathway, you might begin building up hours that you can then use if you find that you failed the bar exam. But again, it depends on what the bar exam is like. There could be ways in which the two would be complementary.
And Emily, I do think that that's a topic that we will be discussing later as far as timing goes. Debbie, I don't see any other hands. I have one last question. We were talking about, you guys really seem to compartmentalize, as Donna pointed out, supervised practice and experiential. And we have looked at the two of them and maybe even combining them. Are there any concerns around that combination as you've thought it through that you want to raise and we should think about?
I think the greatest concern that I would have, and I'll see if Danette and Logan have ideas too, is simply the length of the pathway and the onerousness of it combined to the written exam. You want fairness in these pathways, and to have two options for students, but if one is much more onerous than the other, is that really an option? And if you can accomplish the validity and reliability that you want with either the experiential education or the supervised practice, then why would it need to be combined? Now, there's also, there are so many variations here, right? You could have a much more minimal experiential education and a much more minimal supervised practice, which joined together are similar in burden to the bar exam. I've even heard discuss things like an experiential education pathway, but then have students take the performance test part of the bar exam as a final sort of imprimatur of their skills and knowledge. Logan and Danette, do you have any comments on that?
As is so often the case, Debbie, you literally use the words I was going to use in describing a combined path as potentially onerous. But I don't have any thoughts aside from those that you already mentioned, and I agree with you.
So I'm of course going to be it depends, because psychometricians say that all the time. Well, it depends. I think it depends on what could be accomplished during experiential education to sort of make it fair for everyone, where in a having those hours of supervised practice might supplement, as Debbie said, if the experiential experience is minimal. And I think that's something that you've actually discussed with some of the schools. How can we improve what's done during clinic so that would be considered part of an hour requirement that would mean supervised practice of some sort. But I think it's important to think about this experiential pathway as just a form of supervised practice. In medical education, there's 2 years of actual experience with patients, and then they go on to postgraduate training that is hands-on stuff before they're certified. So the thing for me is thinking you're giving out a general license, and will you have enough variety during experiential training to be able to say that that's the general practice that we're licensing you to perform.
Tracy?
Yes, so building off that comment, my concern with the this is more of a comment for the members to think about. My concern about just a supervised pathway is that it may not prepare the individual in terms of that minimum competency, that well-rounded experience with it, which is an expectation of licensure. I know listening to these provisional licensed individuals who spoke before, they all had very specific focuses of where they were working. getting great experience, obviously, and developing their skill set. But upon licensure entry level, we have an expectation of this sort of wide range of knowledge. So I definitely like going back to the comment of some kind of combination, but maybe on a much smaller scale. Again, where we are at DCA is moving away from practical type performance exams, maybe letting the schools do that. So that's where I see that experiential component. And then after that, having a much scaled down exam that can be very standardized. I love all this information. It's great. And trying to kind of whittle it down into something manageable is going to be a big task. Thank you.
If I could just offer one comment on that, because it's something that our team has talked about among ourselves. In law, a lot of the foundational knowledge is expressed even in very specific practice areas. So if you're practicing family law, for example, you're going to be borrowing concepts of intent that you learned in criminal law, in tort law. You're going to be incorporating some elements of property law from the first year. So it's interesting in law that our practice areas don't necessarily correspond with those foundational concepts. And then you add to that the fact that research is such a fundamental part of law in learning how to do new things. I mean, if you look at newly licensed lawyers, many of them are thrown into areas where they have no experience whatsoever. They haven't taken a course in that. And the way that they survive and show their minimum competence is because of those foundational courses that kind of feed in to all of these different practice areas and their ability to see issues and do research. So we've had really interesting discussions about that. So I just wanted to throw that out.
Well, I think Debbie, Logan, Danette, thank you for the presentation and answering the questions. This is really helpful and helps guide us. Audrey, what I'd like to do at this point, I think it's a good time and a place to take a break. Maybe we can do a 15-minute break, come back at 12:25, and then we can move back to the framework.
Sounds good. Thank you so much for the presentation.
Thank you for having us, and let us know if you have further questions.
Thank you.
All right, Audrey, let's go ahead and get started. Looks like we have most of the folks back. They should be coming back.
Sounds good. Okay, I will share my screen. Okay, so I think actually that was really helpful to have that presentation before more of these decision points today. This is the first one. Does the non-exam pathway begin in law school? That's what we posited at the last meeting, but obviously there's lots of discussion here. So, and it's just this slide, so I can leave that up there, but maybe we'll just look at each other while we talk about this.
Yeah, that's a little better. Thanks. Okay, well, I'm just going to open it up for discussion to start. Jackie, let's start with you.
Yeah, thank you. I just have a question first to make sure I understand, because there is an experiential pathway that could begin in law school and then be combined. But I also think of law school as a foundational place that would include, for example, the knowledge domains that came out of CAPA, and you would start in law school, even if you didn't do a clinic or an experiential pathway, putting that aside for the moment. Would there be an expectation that those knowledge domains would be built in law school? So, for example, administrative law was identified by CAPA as something that should be tested on the bar exam. Would there be an expectation, even for those students who may be choosing an alternative pathway, to still be exposed to and develop some minimal competence in the knowledge domains in law school?
I don't know who's the right person to answer that, but I'm going to jump in just because I have some thoughts on it, and then Audrey, please. It looks like you do also. I mean, we obviously are working today and the last meeting, the next meeting, around non-exam alternatives. We have recommendations also that we have come to some consensus on regarding some exam alternatives and changes that we think would make sense. And I think those changes, including some findings in CAPA, are I'm going to assume, and I'll leave that up to the academics here, are going to drive the law school curriculum over time, as those are added, if they were to be added to the exam pathway. In the same way, if they were added to the non-exam pathway, if that became a supervised practice that was not law school driven, I am sure the law schools would work their curriculum and around those areas that are being tested. But I don't know that it's in front of us necessarily. I see this gating question as, is there a separate path that begins in law school, whether that is an experiential path that then goes to supervised practice, or just an experiential path? Is there one that begins in law school, or is there another approach that we could discuss and potentially have some kind of supervised practice that you don't need to choose that path during law school? That's kind of how I've seen it, but again, I'm open to everybody else's thoughts on that.
Just one thing before we get to Judge Reiser. So I was thinking we made those CAPA recommendations for skills and CAPA recommendations for legal topics at the April 6th meeting for the exam pathway, imagining that we would also make similar recommendations for a non-exam pathway is what my thinking was going into these past two meetings.
And thank you for that. I think the problem that I'm having is that it seems to me everything starts in the law school. So when we're saying, does it include the law school or doesn't it? It seems like if we're thinking about it in that way, it includes the law school, whether or not it's experiential into supervised experiential alone or supervision alone. The law school does have an obligation or responsibility when it comes to laying a foundation. So I guess that's the nuance I'm trying to get my head around.
I think that's a fair nuance. Maybe the question is, and believe me, a lot of this is maybe not as artful as it could be as we cut through it. Audrey, please don't take that personally. But yeah, I think the question that we were hoping to think about is more specific to a path in law school than the law school itself. I agree with you that no matter what direction we recommend, if the board of directors and the court decides that that's a direction they want to go in, they're going to need to have the law schools as part of the conversation in order to make sure that it's successful. So I was, let's see what other members have and we'll go from there. Judge?
So I mean, instinctively, right? They seem to be two, while related pathways, seem to be separate concepts, because to me, and I love having all of this law school input on the commission, because, you know, professors, deans, they shape minds and they are training, ramping up young minds, not always young, but for the law, they're young minds, to be lawyers or people in industry with law skills who are going to be in that world for the next 60 years, right? But that's going to take some time to ramp up. From my perspective as a career judge, right, I think about remedial issues because that's what I do for a living, right? And there are literally thousands of people past who've been foreclosed from the ability to practice their chosen profession, which is law, because of their inability to pass the memory test. I get that. And there needs to be, and not just for the provisional licensees from the COVID allowance, but, you know, there are decades of people who would be competent lawyers who have been unable to practice. So this kind of allowance is remedial to some extent. It's DEI driven to a second degree, but there's also, it's also something that could be launched much sooner than the ramp up of these experiential courses that I agree with my law school colleagues are a viable means, if done properly, to licensure.
Emily?
So I like, Joshua, you framed this as the gating question, and that kind of resonates with me. It's like, how does somebody get to be able to do this pathway or a pathway, a non-exam pathway? And so I also just wanted to mention, so right now, law students are required to do 252 hours of experiential learning, 84 hours that is directly attributable to either classroom experience or something, and then 2 hours for every hour is their own sort of thought work, etc. So 252 hours is what the standard is across the country based on ABA rules. If we wanted to do more than that, certainly that is, you know, an option. I would just say on the question that Audrey poses, I do think if the gating question is, or if the issue is, do we start in law school? I think the answer has to be that we have to in some way, right? I mean, we have to start with law school, period. And I don't think that we would want somebody that is going to advance into a supervised pathway to not have basic understanding of the knowledge base that we want for the bar exam or the skills requirements. So I guess I would submit that having the supervised pathway, if that's what we go for, and forgive me because I'm mixing words here, but experiential or supervised. But if we have a non-exam pathway start in law school with the foundational classes that are required or one would take for bar exam topics, which would include mostly first year classes technically right now, but would obviously include evidence and administrative law and criminal procedure, then you know, if that's sort of the threshold minimum that you have to take and pass those classes, and then you also are doing, already you're doing 252 hours of experiential work, is that enough of a gate to get to what might be a supervised pathway of 750 hours or something after one graduates? And again, I don't know that those are the numbers, but that would also allow people who are not in California schools to meet that requirement also, right? If they're in Colorado and they know they want to take California, they know they're going to have to take administrative law, evidence, and Crim Pro in addition to their first year courses, and they already have to meet the requirement of the units for experiential. So that would sort of be at least my starting point. I don't know that I would add, I know that we certainly could, right? We could do, as Debbie has suggested, sort of add a lot to the experiential component and then have people graduate California law school and be ready to practice. Makes me a little nervous, but that could be, and there could be somewhere in between. But I guess I would say that to me, the threshold question is minimally, I would want somebody to take those classes and complete their experiential requirement.
Audrey, I'm going to suggest that we go to the next slide for a moment,
Okay.
and we may come back. And my reasoning for that is that I'm going to try to keep this conversation in some kind of linear fashion, although that's very difficult, and we'll probably keep coming back around. But you know, the next question really is which law schools, and Emily hit on that when she started talking about out of state, which is coming up also later in the conversation. So when you say that it begins in law schools, I understand that and agree with that. But is there a distinction we need to make between law schools and distinction in California law schools versus other out-of-state law schools? Obviously, ABA versus Cal accredited, etc. And I apologize, but Audrey, once you do that, I can't see hands if there are any. Stuck in. Hold on one sec.
I don't see any.
Okay. Does anybody have any thoughts or comments on distinctions in law schools and whether they should be made? I see Susan's hand. Susan?
Just to make a preliminary point, Josh, I think we have sort of two competing concerns here. One is to create a non-exam path that has access, and that means not using law school differentiators, but trying to create a path that any law school could potentially qualify to provide. On the other hand, if we're talking about realistic scalability, we do have distinctions in our state, and using those as a starting place is not, I mean, makes some sense, or at least I can see would be attractive to some folks. I belong in the camp of access is more important, and we should try to craft a plan that any law school could qualify for, but I think we'd be wrong not to recognize that at least potentially very small unregistered schools would likely be unable to do so.
And they would be, you believe, unable because they wouldn't have the resources or the programs to do it?
I think that it's difficult to say without the data, right? We have the ABA data that Debbie summarized this morning about ABA schools appear to have the necessary seats available. And I think many of the California accredited schools also do as well. My concern about unregistered schools is that many of them are very small. And it is, I do believe, a resource issue, that it is expensive to provide live clinic. It is expensive to provide oversight and training that's necessary for proper experiential programs.
On the scalability issue, I'm just curious whether or not the other members of this commission agree. I think that our job is to make recommendations. As far as scalability, I mean, I think the court and the board will decide, and I think prudence will prevail ultimately, and it probably will start at some size in which it can be tested and proved. And I understand that the balance with access is difficult, but That's kind of my assumption. And so I don't want to spend too much time being bogged down in scalability, because I do think that that's going to just time is going to tell. Other thoughts on law school distinctions? We can try. I guess there's another question, and Audrey, if you see hands, please let me know, because it's hard on the screen
hands.
for me. There's another distinction that I want to see if we can talk about, which is the one we were making during the last presentation: experiential versus supervised practice. And I know that a couple of folks voice a desire to have both, and possibly in shorter time periods or some limitations. I'd like to try to get some thoughts on that. If there's a direction that the group feels more strongly about, whether or not experiential alone would be successful, whether or not experiential with supervised practice would give everybody more comfort, or whether or not a supervised practice on its own. Judge.
So I heard what the speaker said loud and clearly about trying to load up too much on the plate of alternative pathway, right? Where if you take these, we'll call it a skills-based experiential course in law school, and then you're loaded up with additional post-learning supervised practice, it becomes kind of becomes such a major burden that I would expect most people to prefer the swiftness of an exam, to that kind of an option. And I'm not sure that provides the relief that we're looking for. I mean, I can't translate it to practice, but at least the expert thought that was problematic.
Well, let me ask real quickly, because I heard that also, but I guess I was making some assumptions that experiential could be partially during the time, would be during the time that you were in law school, and there would be a short supervised period that maybe would be similar in time to studying for, taking, and receiving results in a bar exam. And trying to track those so that the paths weren't one longer than the other necessarily. I found that to be part of the onerous argument, maybe not entirely, but part of it. I don't know if that would make a difference.
I see Jackie and Tracy's hands as well, Josh.
Jackie?
Yeah, thank you. So I agree with Emily that I would like it to have a law school component and a post-graduation component. I think, and that's putting Judge Reeser's very, I think, good comments aside regarding those who have already completed law school and wouldn't necessarily have the opportunity to go back and complete what might become part of a licensing scheme going forward. So for our PLLs right now, for example, who spoke to us this morning. But this is just going forward, a law school component. And I have a master's in social work, and I had to do my classroom component, a small bit of clinical component, and then I had to have hours of practice before I could get what was called an independent license. I had a preliminary license right out of my MSW program, but I had to get hours of practice before I could have an independent license that would allow me to bill, that would allow me to put a shingle out on my own. So I think there's examples out there where we can think about how to combine both a school requirement along with a minimal practice component, especially if it's like a PLL program where they're able to work, make money, as well as build those hours in. I still like to think about it in terms of what's a product that they might have to produce, or or other things as opposed to just logging hours, but that might be a next step in the conversation.
Okay, I'm going to turn to Tracy first, and then if Dr. Henderson, if you wanted to have any comments on, it's probably a good time on that topic also, and then we'll go to Susan. Tracy.
So I'm going to just kind of echo Emily and Jackie. I think having certain courses being required in school and then also counting those hours would be very helpful. And then a supervised practice that would include rubrics, kind of a structured set of expectations of what would be occurring and demonstrated during that supervised practice with a possible product as well. So you would ensure that all those core competencies, knowledge, and skills identified in the CAPA report have been ticked off as far as demonstrating a level of competence. Thank you.
Dr. Henderson.
Thank you. I believe that the supervised practice route alone would, without the experiential program in a law school, would be problematic. And because of the difficulty in achieving the breadth of sample across all of law that would go into that, the benefit of involving the law schools and having the experiential program in law school is to ensure that students are exposed broadly and assessed broadly across law. So I think that it's possible to structure a supervised entry to practice to address that. But I think that the better approach would be to include the law schools.
Susan?
I just want to add one point. I agree with Emily and Jackie and Dr. Henderson that a program that starts in the law school and includes a minimal, and I think that's really the key component, is a minimal supervised practice component, is a workable combination of a non-exam pathway that's both fair and accessible, and that we meet a lot of our goals. But here's where I have one concern, and that is if this pathway, if the in-law school requirements require you to really choose between either taking the bar exam or doing the experiential path, we have a problem. Because as someone with over 30 years experience working with students who flunk the California bar exam, I'm going to tell you how incredibly unpredictable it is who these folks are. And while it's not surprising that many of the folks will come from the bottom of their law school class, they do not exclusively come from there. And I worry that we create more of the problem that we heard such eloquent voices today during public comment, that we create another big set of students who cannot pass the exam, who did not take the experiential path in law school because they were anticipating passing that exam. And all we do is exacerbate what is already the problem Judge Reeser has stated, that we have a large group of people who cannot practice in their profession because the exam is barring them. So I would like to see that we create a path that is both effective at ensuring minimum competency, but not onerous at all, that it is possible to prepare for the exam and to prepare for the experiential learning, which in my experience in today's law schools is very possible with the breadth of most curriculums.
Dr. Henderson, your hand's still up. Okay. Susan, how exactly could that work? I mean, would it be as simple as you have a normal law school curriculum, and in that you would need to choose, one or more extern / practicum, some kind of criteria with a certain number of hours, but which would allow you then to move towards supervised practice or take the bar exam? So you don't have to necessarily pick a path, but you'd have to pick a class that has that portion that allow you to build the work product.
I think that the Oregon model that Debbie basically started to preview today, where students are given choices, take this or this, take one of these, two of these. I think if we create a lot of options in the program, then it's not really choosing a path. But I think if we make the experiential learning path much greater than it currently is, and as Emily pointed out, it's already over 250 hours. If we make it very narrow and very specific, that we will have a problem with students are not going to be able to choose, and students who choose the exam path could end up being in a barred situation if they are a surprise that they don't pass. That it will not be easy to somehow go back and pick up the experiential requirements and then move into a supervised practice. Now, a supervised practice option alone solves that problem, or at least minimizes it. But as Dr. Henderson has pointed out, it creates different issues. So I think the biggest factor here is the onerous nature, that it needs to be a true minimum competency, alternative requirements in law schools, many of which are probably already met by ABA and graduation requirements at a lot of law schools, at least ABA schools, and probably many of the California accredited as well. And then a minimal post-grad supervision, so that again, that the timing does not result in students choosing to take the exam because the non-exam path takes too long.
Tracy?
Yes, Amy, can you remind me where are students struggling the most to pass the bar exam? Is it the multiple choice? Is it the essay? Do we share that information publicly?
Well, we have reports when we report out our bar results. We report them, our pass rates based on the essay questions, the overall score. So this is the total scaled score. So it's a combination. 50% is our essays and PT, and 50% is the MBE. What we do report as part of that when we put out results is what California looks like overall, like where does California score compared to other jurisdictions or nationally when we report out the MBE. So in terms of determining which, of both the 50% of the MBE or the 50% of the essay portions, which one is more problematic, we don't conduct a report on that level of analysis.
Okay. I would just say I agree. I think it would be good to have a situation where candidates could prepare for the exam and be doing supervised experience. And I'm just struggling with, again, how to address the complexity of the examination and where candidates seem to have challenges that could be better assessed in a different way. So, and I'm just going to use the essay again, because we know from our work at DCA, essays have been challenging and problematic. Is if that's something that can be part of what the law schools are doing. And again, just throwing this out there as that piece. And then, the exam is more of a multiple choice, very basic understanding. And then of course, you've got your supervised practice that gets at that client interaction and even some of the writing skills and things like that. So again, just a thought.
Emily?
So I guess another threshold question that I have not even answered myself that I'll just sort of throw out is, do we want a non-exam pathway to be the norm? Or do we want an exam to be the norm? Because if what we're talking about is we're going to have a certain level of whatever it is in law school, and then a minimal amount of supervised practice after, and they are the same at the same level of time that one can complete, I can see a shift for people to say, yes, I'm sorry, just so I'm clear, I graduate, I get paid for doing legal work. I don't have to take an exam, and I have to really get a lot better at my legal skills with some feedback and all of this wonderful thing. Of course, I'm going to do that, right? So I will just say that when we think about an alternative pathway, we're really, where I think we're leading is not necessarily an alternative pathway. It is the pathway, and that the exam might be the alternative one. And so I'll just say, again, I haven't sort of decided on this, but is that where we want to go? And if not, do we want to know or decide a little bit more about what the exam timing might be, and understanding, you know, kind of what the, make some recommendations about what the alternative non-exam pathway should be based on that timing. I mean, the timing seems really artificial, so I don't mean to say it's just that, but if we are looking for minimum competence in some other way than an exam that ends up being easier than the exam, is that okay?
Emily, I want to address your question for a second, and then go to the judge. I personally do not ask myself that question. I sometimes look back at our guiding principles kind of as a North Star, and I think that I ask myself, what is the ultimate result sometime down the road, but not whether or not we want one or the other. As long as it's accomplishing what I believe our guiding principles are, and successfully, and if the non-exam pathway took over time because we found it to be a better result, that I wouldn't have a problem with that necessarily, but I don't try to decipher between the two today, personally. Judge?
So I agree with what Josh just said. And the question I was going to ask Emily is, do we have to decide that question, right? Can't we just see where this goes? You know, where the students go, where society goes, what's considered a better option? Because when you call easier, you know, we're envisioning it's going to take a year longer, conceivably, right? So I'm not sure longer is necessarily easier. More guided, more supervised, more hand-holding at some level, absolutely. But easier, don't know if that's really the case. You know, 3 months of hell is not easy, but or 6 weeks of hell is not easy. But I'm not sure we really need to decide that question, though it is certainly sort of looming off in the horizon.
Yeah, I guess I would say that I wasn't thinking this would be a year of supervised practice, right? It sounds like people are saying it's going to be the same amount of time as one would study for the bar exam. And if that's not what people are saying, let me know. But that's sort of what I had heard, or not study for the bar exam, but 750 hours roughly is October, and exams in July, and they have to wait for results until November right now. So that's where I'm thinking, like, we're trying to, I have heard people trying to make the timing of these two paths the same, which again may be fine. And I agree. I mean, I get your point, Josh and Judge. I just feel like maybe we don't have to decide that, but I can see people questioning, are we really doing an alternative here? So.
And I agree, Emily, to the extent we shorten we so curtail the supervision time that it becomes a nullity, right? But the numbers I was hearing from, you know, outside California was what, 1,500 hours, and the speakers this morning, the public participants, they were loading up 2,000 plus hours in their public interest work, and so to me, that's, you know, that it's not easier, it's harder. And they've done the work, but I'm not sure we have to decide that. As long as you're right, as long as we create some degree of equivalence, and not just create a sort of a wink.
Dr. Henderson.
Thank you. I think that there are a couple of ways of thinking about difficulty. One is logistical difficulty, that an extra year or another 1,500 hours would be required over and above graduation from law school, would be logistically more difficult. If we end up, though, with, it's another way of thinking about difficulty is the level of proficiency that's required to earn the license. And if we end up with a level of proficiency that's required to earn the license that is different, lower than what is required for the examination pathway, then I think we have done the public a serious disservice. And so I think we just need to, I mean, English is very limited in its ability to communicate things. But, you know, are we talking about logistical difficulty, or are we talking about difficulty as a lower level of proficiency? It really, I think, is an important point.
Jackie?
Yeah, I think I want to echo what Dr. Henderson said, if I understood it correctly. But I want us to perhaps get away from hours and time, because one of the things I think that we do a disservice to those training to be lawyers is we've set up an educational system that's based on time. You take civil procedure for a semester, you take crim law for a semester, whether or not you're proficient at the end of that semester based on a C- in the class or an A on the class, you're moving along. And it seems to me that what I hope we're doing is saying, what is it that they would need to demonstrate, both in terms of knowledge and skills, before the state of California would grant them a full license to practice. And we assume right now that 1390 on a standardized exam over 2 days establishes that. So then the question for me is, what will establish it in a practice environment? And it could be 750 hours is totally fine for someone. They could absolutely demonstrate what we want them to demonstrate within that 750 hours. It could be 1,000 hours for somebody else, just based on life circumstances and their background, English proficiency, whatever the case may be. So I'm wondering if what we want to do is actually set that goal of what would they need to demonstrate, rather than say 750 hours is going to be sufficient for everyone.
Donna?
I'm going to build off of what Jackie was saying, because she was really heading in the same direction that I was thinking. I was really, I think, maybe a little perplexed that we were talking about one pathway being easier than the other, because in my mind, what we're talking about is two different ways to establish minimum competence. And if minimum competence is going to, what is minimum competence is basically defined the same way. It's how do you demonstrate, as Jackie was saying, how do you demonstrate that you've met the minimum competence? But minimum competence is the same regardless of which pathway. So I don't think it's a question of easier. It's a question of sort of how you demonstrate that you have the competence, whether you're taking the exam or whether you're doing it through this through a non-exam pathway. And I was intrigued by Jackie's comment about time, because I think maybe we are, I think we're talking about a minimum number of hours, potentially. I don't know that I don't know if people would be comfortable saying you need to produce a portfolio of X size, and for a person who's able to do that in a day, great, then you're done. I'm not sure that the commission would be there. So it might be that there's a minimum number of hours, but what struck me as Jackie was talking, at the staff level, we've been having these conversations of, well, what happens at the end of the period when somebody is reviewing your portfolio, they say, sorry, not good enough. Under Jackie's described program, that would mean, sorry, not good enough. You need to stay in supervised practice longer. It doesn't mean you're out and then you would have to go a bar exam route. But the 700, you put in the 750 hours, the portfolio doesn't demonstrate the level of minimum competence that we've defined. And so for you, I think you're going to need, another 250 hours in order to meet that. So I was just sort of, Jackie and I were heading in the same direction, and I really appreciated that she, as always, sort of took it one step further.
Audrey, you want to say something?
Yes, and I know, Emily, your hand's up, but what it's sort of reminding me of is how the articling or the supervised practice works in several Canadian jurisdictions where they're doing that prep program at the same time. So if they did not prove competency in some area of what they've outlined in this prep program, where they do all sorts of virtual and in-person sort of lawyering skills along with their supervised practice, then they could repeat that and prove their competency and move on. And so it may not be one size fits all with a bucket of time, but then it's like discrete provable skills that are checked off, even if you have to do one part of it 3 times.
Emily, I'm gonna call on you, but right before I do, there are a number of members that have not participated. That's fine, but if you feel the need to, love to hear from everybody, get an idea of where the body's headed and what people's thought process are. So please feel free to also jump in. Emily?
Thank you. Yes, please feel free. I will stop talking. I guess I just want to echo that at no point was I considering out like 750 hours and we're done. I think when Debbie's talking about doing a portfolio, certainly there has to be something that the bar examiners assess, turned in, the supervisor has to, and Logan was talking about having to do the training and all that. But I do think that there is going to become a path, and this is sort of, I think, Donna's point that, we want 2 paths, and that neither one is necessarily easier to demonstrate minimum competence, but both clearly, if you take either one, will demonstrate minimum competence or not, right? Exam or an experiential or supervised pathway. But I am just trying, and again, we can advance the points further. I do think that if for example, a law student that I worked with has all of the things in the portfolio to demonstrate minimum competence, a week after graduating, which is possible if they're already working for somebody, and there's no hours component to it. There's no requirement that this be over a period of time certain, etc. But they have to show a portfolio and have it signed off. Students could be working on that in law school, and maybe that's okay also, even if it's sort of outside with an employer. So I guess my thought is, in this soup that we are stirring, thinking about, do we need to have a time frame in which somebody does provide these hours and hours over time and get all of these things in their portfolio and show that they can draft a motion and get the a video of them doing a deposition or whatever it happens to be. That's the reason, I think, to have a time component to it. Thanks.
Tracy?
Again, just some, whoops, hold on.
Oh. Some motion light.
Yes. Sorry about that. It's driving me nuts. Again, not to be, a downer, because again, I support all this. I think sometimes when we think of things being easier, we tend to use the word easier. It's because of standardization and the fact that when you do supervised experience or things outside of a traditional exam, you lose standardization. You increase more error. Again, I have a number of programs here at our department that use the supervised experience. We just heard an example from Jackie with social workers. They do 3,000 hours. And one of the frustrations that we hear from our board is supervisors just sign off, just sign off. And so I think that there are, concerns in general with supervised experience pathways, which is why we talk about having those rubrics, some time frames, some standards, so that whether it's the exam pathway or the supervised, there is a certain amount of standardization and equivalence in those things being assessed. And so I just want to, remind the commission too that, it's really important we think that it's consumer client protection is the utmost. And if we build in too many benchmarks and ratings, and again, I'm all for remediation and helping people, we really get away from that. Because isn't that what the schools are supposed to do? Aren't you supposed to graduate and have a basic level of competency? And then you take a test, you pass, and you go out and practice, and you become experts in areas. So I just, again, want to remind everybody, we don't want to get too complicated in this or start setting different expectations, because we're moving away from criterion reference measurement, high stakes exam. We're going more into normative, what is done in education and schools, and those are different things. So I think it's important as members, we think about that as we make these decisions. Thank you.
I'm going to change direction and just dig into one point for a minute, because I think it's important that we think about it before we kind of can make some decisions. Audrey, can you just share for a moment so people can see it on your supervised practice decision 3 on how supervisors supervised and how our applicants matched, and then we can take it down, but just so folks have a chance to look at it. I mean, we're talking about in many cases having a supervised practice portion, and in doing so there are some difficulties in it and challenges, and so I'd like to just spend a minute to discuss if anybody's thought about, and I know we've had some conversations, but maybe a little more detailed in what would it look like, how do we find the supervisors, how are they over, what is the oversight, how are the applicants matched? I know that was a concern in starting the provisional licensing program in 2020, and making sure that there were enough supervisors sourced for all of the folks that wanted to participate. Thanks, Audrey. I think that's enough to get started. Anybody have any thoughts on that? I mean, I do remember one of our meetings, I think it was Susan was talking about her university specifically, and the number of programs they have and the alumni that participate, and she thought that it would be easy to find a large number that would want to support. But that may just be because of a single university, and obviously there will be a lot of other folks that don't have that. So how do we bridge that gap? Susan?
I think this is a little bit of, if we build it, they will come. And I think we have to appreciate that it's difficult to anticipate in advance who will sign up for a program that doesn't exist today. But I was really encouraged today by something important we heard from the presentation, and that was that we need to be careful not to assume that supervisor selection and training we need to use that easy cut score or cheat of sort of years of service or years of practice. I was encouraged to hear that, it is true. Young government lawyers get a lot of responsibility very quickly. And it would be just fine to have a second or third year DA supervising students and making those kinds of assessments and approvals, because they have the necessary experience. So I think that traditionally we have often looked to more senior lawyers to do this kind of thing. I think we also want to to go back to our most recent conversation just a minute ago, think about if some of these products are going to be prepared in law school, there may be a professor relationship that can continue into the postgraduate process that I would continue to help a student I had worked with. And I think we might have an ability for students to create some products during law school that could be in their portfolio. We might be able to think more broadly about supervisors and who they might be. And we might be able to let the law schools, alumni, and all kinds of professional organizations. I'm thinking of everything from regional bar associations to subject matter specific bar associations, particularly bar associations that have shortages and have trouble hiring young lawyers. They might be very happy to involve themselves in these kinds of processes. I think we have to think creatively, but bottom line, I think if we build it, they'll come.
Susan, I want to pose a question off of what you just said, and I apologize if I haven't thought through it far enough. But you said something that struck a nerve with me, which is I have some concerns that there will be more folks, supervisors in the government admin public interest space. And I think that's fantastic because obviously that's an area that we need more attorneys and we'd be able to help. But at the same time, I'm afraid of creating two paths where certain industries go or certain areas of practice go one path and other areas go another path. Does anybody else have that concern with and how would we remedy it, or am I completely off base on that? Judge?
So when I think about supervised practice outside of the law school setting, right, to me, the lowest hanging fruit is the public interest sector. I think Claire Salat has been submitting a number of thoughts and expressing some support for that. So that solves multiple problems, right? It solves the supervised practice pathway problem, and also solves we'll call it the marginalized community or disadvantaged community issue to some degree. And then I think Donna brought this up at the last meeting, we have areas of California where there's a dearth of lawyers, where they need lawyers. And so that's also, middle hanging fruit in terms of if we have a pilot program with respect to a supervised practice pathway, and I'm not necessarily suggesting that, but it certainly seems more palatable to if we're going to move forward on that, to perhaps begin with some of that lower hanging fruit. Just conceptually, it's a thought that just keeps ringing in my head.
Susan?
I agree with your concern, Josh, that there'll be potentially more supervisors more quickly in government areas and in public interest. But I think we'd be wrong to underestimate that private law firms are not going to come through here. And the reason I'm going to say that is it may be true that the very large white shoe law firms are not coming to this program, and that's fine. The grads will take the exam, they'll take the bar, they'll do a different path. But I do think mid-size and small-size firms in California are going to come because of personal relationships. Because I think every one of us that works at a law school can tell you thousands of stories of students who did not pass the exam and their employer was willing to do anything to get them licensed because they didn't want to let them go. They'd had them for several years as a clerk. They've had them as a PLL, whatever it may be. And I think that some of the extension of the PLL program and some of the stories we heard from the PLL grads today further that message is there's personal relationships. People want to be able to complete that licensure last step, and they want that approval. And I do think that you would see smaller firms and mid-sized firms willing to do it on a one-on-one basis when they realize this clerk we want to keep needs us to do it.
Around supervised practice, the next question that we kind of talked about, or was being posed, is, what is the oversight of the supervisor? And so, Susan, when you say a lot of people at one point you think would come forward, and I do agree with that, but it sounds like that we would need, and I think this is probably a place where the bar would play a role. There would be some kind of oversight, or at least training that would need to take place. And so just curious on what thoughts around that training and oversight, and maybe Dr. Henderson or Tracy, that might be an area that you can touch on a little bit if you've seen it before.
I'm sorry, I didn't hear the last part of what you said.
Just looking for what kind of requirements around the supervisors that would be part of the supervised practice. And so obviously the bar would have an obligation, I'm assuming it's the bar, but I don't want to make assumptions, of making sure that those folks are, properly certified or ready to play that role. And I'm just curious on if you've seen that before. We talked about it with a couple of people that have come to present to us, but how we handle that. Or is it an issue?
I think it's definitely an issue. I guess I have several concerns around the selection of supervisors and their supervision and evaluation. The selection could well suffer from the kinds of limitations that you expressed concern about a few minutes ago. The private practices may be unwilling or unable to devote the kind of time that other practice settings might be able to make available. And I think that's detrimental. I think that you could conceivably end up creating two classes of attorneys, those that are headed into the private firm and they're going to take the bar exam and everything will be done and set, and the others who will be perceived potentially as less well qualified because they weren't able to complete a supervised practice in an environment that would put them in that private practice setting. I'm not an attorney. I don't know law all that well, but it seems a potential issue to me. I think that the supervision of supervisors has to be really pretty well structured and tight. I think that it's the relationship that forms between the young attorney and the supervisor extending over some period of time, the supervisor investing some of himself or herself in that individual, forms a relationship. And to some extent, it becomes more difficult for that supervisor to make a negative decision at the end about that young attorney. Also, part of the difficulty is not just the relationship, but the effort that the individual has invested in the young attorney. In a sense, making a negative decision about the proficiency of the young attorney is making a negative decision about the supervisor's own level of proficiency, an assessment that they're probably not willing to make. So I think that, as Tracy said a few minutes ago, maintaining as much standardization in this process as you possibly can is really extremely important. So that, in addition to what we heard this morning was really good experience that people had, but it was focused as well. That's an example of the kind of breadth of scope concern that I expressed earlier. You're going to be a really good real estate attorney because that's where they did their supervised practice. And if they might not, but their license will qualify them to do any other kind of law. So I think the supervision of supervisors is critically important.
Jackie?
Yes, thank you. I just do want to make a comment about a concern that I have as it relates to California accredited law school and registered law school graduates being able to access supervision. Obviously, it's a huge investment by any firm or government agency or other entity that might take on the supervision of a new law school graduate in this pathway. And there are employers out there that simply will not hire anyone who isn't a graduate from an ABA law school, which may be a disincentive for them to invest the time, energy, and money in the supervision pathway piece. And it's just a much smaller alumni group than some of the larger ABA law schools. And so just not the range necessarily available. I can tell you In the PLL program, some of our graduates very much struggled to find a supervisor, both those who took advantage of the 1390 and above score pathway, as well as those currently in it. And so I don't want to kind of diminish that it might be an issue for some graduates and an equity issue overall.
Thank you. Tracy?
I was just going to echo with regard to supervisors and the bar having some guidance over that. Typically with our social workers and marriage and family therapists, again, supervisors need to be licensed and in good standing, which is what we saw in the presentation. They also have to have like a contract that basically talks about that relationship that Dr. Henderson said. And then they're also required to have certain direct hours of supervision. So there are some parameters. It's not complex. It's just some very basic parameters to ensure that there is that relationship. And I like the idea of opening it up as much as possible to who can be a supervisor. I think that's a great idea. And one of the reasons in the presentation that they talked about having individuals who had only been licensed for 2 to 3 years, that same thought applies to when we do standard setting or pass score workshops. We actually like to have more newly licensed individuals in that process because they bring the perspective of what minimum competency is at the current time. A lot of times people think that more senior licensees are better in this process, but they've gotten farther removed from the current expectations. So again, I think it's great to use that full range of licensees in the supervision process. Thank you.
Susan?
I'm seeing a relationship between the supervision issues, and I agree with Dr. Henderson and Dr. Montez. I think that there is definitely a need for supervisors to meet strict criteria, to be available widely, and all of the concerns we've raised today. And in particular to Dr. Henderson's point about supervisors get invested and they have personal relationships, and to Dr. Montez's earlier point that sometimes supervisors just sign off. And I wonder if some of the way we work around those issues is the portfolio is reviewed by the state bar. Because if this, I'm a California lawyer, not just a law professor, and I know if I supervised a student and their portfolio was rejected that I had approved, I would be professionally humiliated and embarrassed. And I don't think you're going to have lots of supervisors who are going to routinely just sign off and face the embarrassment of the state bar, first of all, rejecting their applicants, but then secondly, rejecting them as a supervisor in the future.
Yeah, I mean, I can tell you from the time that I spent on the Board of Trustees that the board takes that role very seriously. And I think that if we had any recommendation that didn't have the state bar having some kind of oversight in that manner, we would need to have a very well thought out explanation as to why. So I agree with you on that. All right, folks, we can go 2 directions here. We can just keep moving down the road and kick the can a little bit and move into out of state, which we haven't really touched on. Or we can go back, circle back and have a conversation that digs a little more into where I think at least the members that are participating feel or at least that may be a fair direction moving forward in a recommendation. I think we have I feel like we have some consensus around the idea of having both an experiential and a supervised practice of some period, which I don't think we've really agreed on. And that if that is a direction, then I think there's a couple of large issues we really need to think about, which is what is that length of supervised practice? I understand that some people have said, 1 year and 1,500, and others have said it's got to be short and closer to the time that it would take to take the bar exam and to get your results. I'm not sure we really had consensus on that, or that there was a lot of logic on either side that was expressed. But I think that's one. The other one that we moved past, and I understand how difficult it is with the different people in the room, is there a distinction in the California law schools? I don't want to, we don't have to take it on now, but I don't want to ignore it because the State Bar has made that distinction before. And if we don't think that there is or should be, that's okay. But if we think there is, then we need to express that, because one of the questions is going to be, who could participate in this, and I think there's probably arguments on both sides. I think those are two of the main issues for us if we decided to move forward with a supervised experiential and then a supervised practice recommendation. I'm going to leave those hanging for a moment because I'm just looking at people's faces, and we're going to go to out of state and we're going to come back to it. And we're going to wrap up by 2 o'clock. I can promise all of those things today. So Audrey, let's move to the slide really quickly on out of state, just so that we can have that conversation. So, I mean, in its simplest form, one of the questions is, if we do go this direction, should out of state law schools be able to participate? One of the first problems I see, and I think I want to talk about, is if there's an experiential portion to it, how do they participate?
And these were just some of my own thoughts based on some of our prior conversations about what options could be there for out-of-state law school students to participate.
Anybody have any thoughts on out-of-state?
I see some hands, right? Yes.
Great. Start with you, Emily.
I just had a question about what you just said, Josh. With it, what did you have a problem with?
If I use the word problem, I apologize. I did not mean to. I don't know what you're referencing.
Sorry, I just, and maybe I misheard. I'm wondering why, based on
oh, I think I know. I think I ended by saying, if we choose to if our route is experiential and we're talking about having California law schools that we know have these experiential programs, that will have to be, I don't want to use the word accredited because I don't know what the system will be, but understood what those are, and whether it's hours or program. How do we deal with what is a very large swath of out-of-state schools that may or may not have the same resources or programs? How do we ask them to have that same experiential curriculum? I mean, are they cut out of the program just on that alone, or are we willing to make some other assessment? Maybe just supervised practice if you come from an out-of-state school. That was the question.
Okay, thank you. Because when I'm thinking about this, I mean, if as we have talked about, the ABA standard of 252 hours is what might be required for California schools, California accredited registered schools, et cetera, and that's the standard, then most law schools across the country are going to be able to meet that, because most law schools across the country are ABA accredited. So that kind of goes to Jackie's point too, about not loading too many things into the curriculum within law school as a gate or as a threshold. You certainly could load in things to say, like, well, if you've met these requirements, great, but in law school, one could also do 50 more hours of clinical work or something, and that counts towards this pathway. But I guess I would say that as far as gating, I would do the minimum amount that the ABA requires now for all schools across the board, at least. And I wouldn't have any more, again, I think I've said this, I wouldn't have a more experiential path in that, because otherwise you are going to have problems, not just with But you're going to have problems with scalability, even for ABA accredited schools, if you go more than that.
Let me ask you, because this is, and I asked the folks that are in academia, because that's going to be most helpful here. On the experiential, I mean, is one program equal to another? What is there any oversight? Is it because obviously there's a ABA accredited, but there's in California others, but how would the state of California and the state bar be able to feel comfortable that if there would be some kind of validity around that portion of the program?
Well, it's a great question. I mean, so that if it's an ABA accredited law school, we have to report all of the things that we're doing every year to our accreditor, and we lose our licensing if we don't do everything right. On an individual student basis, so whether or not a student has actually completed the negotiation exercises that he or she or they are asked to do is not something that law schools can have much control over, other than we try to hire the best educators that we possibly can and, kind of keep track of students. So on a global level, there's a lot of sort of the accreditors saying you have to have this great experiential program, and on the on the ground level, I guess there would be as much oversight as there is in any school as to whether or not a professor and a student are actually having a learning experience. And I don't know if that meets your question. I guess I would also say that California sort of, I think, has, and other states have relied on the ABA to make sure that there are these standards for the ABA accredited schools. I don't know what California does for California schools or registered schools about experiential work. So maybe that's something, if there is a requirement for that, I don't know it.
I guess I'm going to go to the judge in 1 second. I guess the question I have, and I just don't know, Emily, is around the ABA accreditation. Maybe Amy or someone else does. How much of that is focused on the experiential side of the curriculum, and is the ABA accreditation enough to give everybody comfort that the programs are doing what we think they're doing in that space?
Josh, I just want to mention 2 things. One is in response. One is that so ABA schools are required to provide experiential training courses. So are California accredited and law schools as well. And I believe registered law schools have a similar, requirement. That's the first thing. But also when I think about how we handle, for example, applicants who want to participate in the practical training of law, so they are able to work or clerk in a court, they are required. We have a requirement. They're required to get a sign off from their dean, from a supervising attorney that's going to supervise them in that practice. And then from the student, they have to attest that they have finished or satisfied certain course requirements before participating. What I imagine is that in if, for example, we carried on and we had a program that required some experiential training before you entered a supervised practice, we can follow that kind of format. If all school types are already offering experiential training, I mean, one of the things we could do is, and we also automatically collect transcripts from students when they sign on to sit for the bar exam. So part of your licensing requirement is to provide a transcript. What we could do is use that transcript to determine if there's a minimum threshold of experiential training that's required. We could gather that from the transcript in order to qualify for a supervised practice. I mean, this is just logistically how it could be carried out, which would be similar to what we do with the PTLS program.
Thank you. That was actually very helpful.
Mm-hmm. And I think it's 15 credits in the ABA requirements, which is what I think translates to that many hours. And Emily and Susan, you can correct me.
Yeah, it's 6, not 15.
Oh, it's 6, and it's 6 also in the 6 in the accredited roles, 6 hours of practical training skills. And in the unaccredited rules, it's more vaguely worded as competency training.
Thanks. Judge?
I just wanted to clarify, Jess, that what we're talking about is exclusively out-of-state students who want to qualify for what we're envisioning as a California law school experiential pathway, right? We're not talking about people from out of state who are experienced lawyers and doing other stuff.
That's correct.
Got it. Thank you.
Natalie?
And I apologize, I'm off camera today. I'm not feeling great. But to your question about whether or not we, and by we, I'm speaking for me individually at this point, would feel comfortable with the ABA requirements for these units, and does that mean that we believe the students would have received adequate training? I would say yes, and I would let some of the non-ABA accredited law schools speak to that, but we have to not only report what we're doing, but we also get these site visits where they go through all of our material. They speak to the faculty who are involved in these courses. They speak to students. So it's pretty rigorous to show that we are meeting these requirements. Again, I'm not familiar with these state accredited standards, but if they have some kind of oversight, not just that you report that you're offering these courses, but what's substantively happening in these courses, then yes, I would feel comfortable with that.
Susan?
I'll echo Natalie's comments and agree that I think the ABA standards, and if you have not been subject to an ABA inspection, I think you probably don't have a full appreciation of the level of inspection that it truly is. And I would feel confident that if an ABA school says they've offered 6 units and it meets those requirements, that it does, and that we should have confidence in that material and in that instructional and learning process. I do think this might be an area where, although we've deferred the question of the distinction of California schools for in-state, it might make sense to use the ABA out of state, because it is, as Emily suggested, a great majority of the law schools out of state that take the California bar exam are ABA accredited. So it might give us an easy way to expand the offering to include out of state, to put an ABA restriction on it, though I would not automatically say that applies in California as well. In California, I've stated my opinion before. I think that we should try to allow all law schools in California access to a California program and let them find a way to meet it. But I think for out of state, to keep this contained and to keep this something that the bar can do reasonably, an ABA provision would be an easy cut, an easy line to draw.
And no, I have personally have not been part of an ABA accreditation, and I don't intend to anytime soon. I will leave that to you. But I do have a question. Is there any experiential experience? Are there actual programs where you could take a course under that would fall within the ABA accreditation, but does not involve the CAPA kind of guidelines? I mean, I'm trying to figure out, is it easy enough just to say all of the programs that are offered through the ABA schools, or is it going to be limited to certain ones where it really follows the curriculum that we're trying to follow?
The ABA has detailed standards and definitions. You can't just say this is an experiential course. To give you an example of a quick, easy rule, they have a no double dipping rule. So legal writing, despite the fact that that first year course obviously includes experiential components, is not allowed to count. So one of the things that I think, one of the reasons that those of us at ABA schools feel that this is a decent level of protection and confidence is because the ABA process is rigorous, the rules are very detailed, and the definitions are restrictive.
Josh, I do think, though, there are some ways for students to focus in on the types of learning experiences that they want rather than a breadth. So as much as I am advocating exactly what Susan's talking about. I think in full and fair disclosure that, we've seen students that will use the 252 hours are all spent in a clinic, right? Or they're all spent doing transactional law. So maybe they haven't gotten the exposure to litigation. But I do think that, it's partly why the knowledge base component is also important, that you're going to get exposure. And, when you take civil procedure, you're going to get exposure to litigation, even if you're not necessarily getting that direct experiential with litigation. You're also going to still learn, the drafting and writing and research and investigation and all that in a transactional world, or could, but students could decide that they wanted to really focus on 3 of the 6 areas that we have designated as CAPA topics.
So maybe Josh, what you're saying is, like, would there have to be another level of transcript review to see if this recommendation is that the CAPA CAPA skills and legal topics are what the non-exam pathway will recommend, then do we do another level of transcript review for out of state to see if they've met those topics?
Yeah, there's obviously a number of folks that are very knowledgeable day to day on what this entails. And then there's a number of folks on this call that I think are not as experienced, no pun intended, on those programs. So I'm just trying to dig a little bit so everybody gets a little comfort around what exactly it is and what the oversight is. And maybe I'll ask one more question and then we can move on if nobody else has one. Jackie, I'm curious, is there a way, what would be the easiest way to draw some kind of similarity to the ABA requirement at the non-ABA schools?
So I'm curious about the 252. If we're talking about units, what the accredited law school, and I can't speak to the registered, requires is 6 units like the ABA, but also the opportunity must be in your curriculum for 15 units. Mm-hmm. So students have access for 15 units in total. So all of the accredited law schools mandate 6. We actually mandate more than that for our particular institution, but must make available much more. So what I'm imagining would happen is students who were interested in the non-exam pathway, assuming it becomes available, would gravitate towards those courses that were experiential related because it would better prepare them to establish their competency in the non-exam pathway.
Any other questions around experiential and the qualifications around it? Okay. I think I'm hearing and from folks that there really shouldn't be a distinction out of state if it's an ABA accredited school. Is kind of sounds like the direction to some extent. So you would be able to do the concept would be, as long as you follow those guidelines and you were at an ABA accredited, you would be able to get the experiential, whatever the requirement is that we come up with, or make a recommendation, and ultimately the board and the Supreme Court decide, and then that you would move into supervised practice. Is that kind of the concept that people are thinking might work, Emily?
So I just want to be clear, though, that certainly the 6 units of direct experiential learning is what I think you just summarized. But I had thought also just on our CAPA knowledge topics, administrative law, crim pro, and evidence beyond the first year. That is something that I would also hope would be part of the recommendation as part of the non-exam pathway, and also out of state. So if you are an out of state, candidate, that would be required too. The ABA doesn't require those classes, so that would have to be part of that.
Yeah, but how do you do that? I mean, that's easy said, but some of those, especially, I completely agree with you that every step of the way we've talked about needing to follow the CAPA requirements, with obviously a little bit of a distinction that we made, but very similar. That's how we're going to get to minimum competence. Can you still do that with an out-of-state applicant?
Yeah, I mean, for example, right now, and I say right now because it may have changed, but if I have students that want to take the New York bar, they're typically going to take family law because the New York bar tests that, or has in the past. So it's not that it's necessarily required that they take it, but they want to take it because they're thinking they want to be practicing in New York, and they're going to need to know that for the exam. We also have students that know that if they want to, practice in other states, they're going to have to take different classes, and they kind of, certainly have until their last semester where they could take one of these classes if they wanted to. The other thing I will say is that I think students also have the ability to, they Crim Pro and why am I blanking on the other one? The one that's not administrative law, that's in the evidence. Those are foundational classes that they would be taking for a UBE exam probably anyway. Admin law is really the one that I think that they would have to plan for, but that's one that they could take and is typically offered in every law school. So those are my thoughts. Jackie, you may have others. I see you.
And Josh, I know Donna has her hands raised, but maybe before we close today, maybe we could circle back to motions similar to the ones we did for the exam pathway about the CAPA recommendations and the non-exam pathway. That might be something we can agree on before 8 more minutes pass.
I think, Audrey, I think what might make sense is that we start the next meeting. Don, I'm going to come to you in 1 second. We start the next meeting with some proposed language around the discussion we're having. And because I think it's going to take a little bit of time to work through that, and I really don't want to rush it. And so I think we just pick up with this topic with potential sample resolutions that encompass the conversation. We can have a conversation, change them as we go, and hopefully that will only be the beginning of the meeting, and then we can move on to the other topics. Donna?
So I just want to clarify sort of what I think I'm hearing is, although we're using the term experiential pathway, what I'm really hearing is supervised practice post law school, and that if you go to a ABA law school or a California accredited law school, at potentially registered, I'm not sure of the requirements on those, but that the 252 hours of experiential training that's already required for those schools meets the experiential requirement. So really there is no, from what I'm hearing, we're not talking about having any specific curriculum in law school other than what exists today. It really is just a supervised practice. And so, and I'm not saying anything one way or the other about that direction. I just want to make sure that we're all hearing the conversation the same way. And I see Jackie nodding, so it seems like she was hearing the same thing that I'm hearing, or intending that. And I just want to make sure we're all hearing it the same way, because we're using the term experiential pathway, but it's not sounding that way to me.
Well, let me address it a little bit, because I think that's a fair distinction. Sometimes you also, well, from personally, I was focused on the time frame, Donna, and I was trying to dig in a little bit on the content because I'm not an expert on it. But I could see having some guardrails around the content where it would need to be more CAPA specific, and we would need to make sure that that it covered the topics that we want it to cover, or believe that it should cover. But not necessarily that it had to be a different time frame. Not that there were more hours needed, or that it needed to be extended past your regular law school term. So that was just my take on where I was trying to go and what I thought might make sense. Jackie?
Yeah, and I think I want to go back to a comment I made last time, which was I want to make sure that the centering place for the conversation is what are the competencies that applicant needs to show in order to be licensed in the state of California. Right now, what I know is they have to score at least a 1390 or above on a test, that they have to be knowledgeable in an array of areas. They have to be pretty good at multiple choice questions, and they have to be able to take timed written exams with some proficiency. But if you were to say, here's a non-exam pathway, and this is what they need to show in order to establish the minimum competence for a licensure, I could potentially shift my curriculum or focus my students in a way that isn't about preparing for a multiple choice test, but actually is preparing to draft documents, do client, all those kinds of things. I want to, like, I get the idea of not upsetting the current curriculum apple cart, but I want to make sure that what we're centering the conversation on is the competencies, and then law schools rising to the challenge of helping their students and bar applicants meet those competencies.
Other thoughts, folks? We're gonna wrap up pretty soon. Donna, did that help at all? Obviously, I think there's still a little bit of distance between some of the thoughts on that.
It did, and I think Audrey and Amy and I can regroup after this meeting. I think that this has been an incredibly helpful conversation to get us to decisions at the next meeting, and we are going to focus in on sort of how to sort of structure the decisions, trying to follow, again, as you had said, trying to follow a somewhat linear path here, but sort of structure the decisions based on everything that we've been hearing today.
And what makes the linear path so difficult is that our mission is so broad, yet so focused. It's broad in all of the different ways we can go about it, but focused in we get back to what I call the North Star, minimum competence. And so it can be a little difficult to do that. Susan?
I just wanted to add one point in response to Donna's point. I agree that our conversation did evolve toward a discussion of there would be some classes required to meet the CAPA requirements, some 6 units of ABA experiential or equivalent, and some supervised practice after. But I think we've also been talking about portfolio requirements and sort of Jackie's point about demonstrated proficiencies. So I think when we go back and put in the demonstrated proficiencies, the portfolio review by the state bar, then I think Donna's concerned that we're just saying, well, if you graduate from an ABA school, you've got an experiential path option. I think we're not saying that at all.
That helps.
Okay, folks, any final thoughts? I can say I really appreciate everybody's time and thought process on this, and I know that it just isn't easy. I started with it's complex, but I do think we need to go back to the fact that we are making recommendations here, and we don't always have to get into every detail because it's going to take some time, and folks from a lot of different parts of the legal world to really come up with the ultimate practical solution when we get there. But what I think we're going to do is we're going to break for the day. We're going to come back in our July meeting. We're going to start with some draft resolutions based on the conversations we're having today. Hopefully we can come to some kind of consensus around those. And then we'll move on to the next thorny issue.
And the next meeting is July 19th. Hopefully everyone saw that it was changed.
Robert, anything else we need to do to close?
I think we're good.
Okay. Thank you, everybody. Appreciate it.
Thank you.
Thank you.
Bye, everyone. Thank you.
Thank you.